revenue requirement and cost of capital. Phase 2 hearings are scheduled to commence in January, on January 15th and 16th, and possibly the 17th. And Phase 3 hearings are scheduled for March 25th and 28th. And a final order will be issued by the Commission on or before April 25th, 2025. Let's take appearance of counsel for the parties. We'll begin with Rocky Mountain Power.
Good morning, Mr. Chairman and Commissioners. On behalf of Rocky Mountain Power, there will be several attorneys addressing the Commission during this proceeding. Mr. Ajay Kumar, Ms. Carla Scarcella, Ms. Catherine Smith. I'm Matt Moskin, and this is my colleague Cameron Sabin. Thank you.
Okay, thank you, Mr. Moskin. Let's go to the Division of Public Utilities.
Good morning, Mr. Chair and the Commissioners. Representing the Division of Public Utilities will be Patricia E. Schmidt, I, and Patrick Griecu. Also, we are both from the Attorney General's office. Thank you.
I may need you to say, Patrick, what's your last? What's his
Griecu, G-R-E-C-U.
Okay. All right, let's go to the Office of Consumer Services.
Yes, I'm the AG representing the Office of Consumer Services, Robert Moore. Absent today is my co-counsel, Stephen Schnarr, who's away for family medical issues, but he will be participating in the hearing later this week and examining witnesses.
Okay. And then to your left.
Good morning, Chair and Commissioners. Justina Kobia on behalf of Walmart.
Could you spell your last name again, please?
I can. It's C-A-V-I-G-L-I-A.
Kobia?
Yes.
Ms. Kobia, thank you. All right, let's go. This officer right there.
Good morning, Captain Ashley George on behalf of Federal Executive Agencies.
Captain George, nice to have you with us. All right, and then we'll go next to Mr. Russell.
Yes, good morning. Phil Russell on behalf of the Utah Association of Energy Users.
Okay.
Good morning, Mr. Chair, Commissioners. Michelle King of the law firm Holland & Hart, and I'm here with my colleague Austin Jensen, and we're here on behalf of the Utah Large Customer Group.
Thank you. All right. Yes.
Good morning, Chair and Commissioners. I'm Sophie Hayes, representing Western Resource Advocates.
All right. Are there others who are not seated at council table who are planning on, attorneys are planning on making appearance in this matter? I guess that's everybody. All right. Well, I don't know any of you, so if it takes me a while to get everybody straight, I hope you'll forgive me in advance. We'll try to get, after a day or so, I'm sure I'll know everybody pretty well. I have a couple of preliminary matters I'd like to discuss. First of all, there was a motion filed by Stadion LLC and the Kroger Company. They moved to be excused from Phase 1 of the evidentiary hearing. They didn't submit Phase 1 testimony. They don't intend to cross-examine any witnesses in Phase 1. They have filed testimony in Phase 2 and will attend the Phase 2 hearing. Are there any objections to granting the motion to excuse Stadion and Kroger Company from Phase 1 of the hearing? Seeing none, okay, that motion is granted. No other parties have formally asked to be excused from Phase 1 of the hearing. But if there are others who do not wish to participate in any of the different 3 phases of the hearing, that won't be prejudicial as far as we're concerned if you choose to just participate in one phase, because that is all it involves your client. That's what we'll do. third thing I want to mention is there was a motion filed the day before Thanksgiving by Rocky Mountain Power seeking to have the parties be excused from filing pre-hearing briefs. I guess everybody assumed we would grant that because no one filed a pre-hearing brief. And no party objected to that motion, so no pre-hearing briefs were filed, and discussion was raised, or a point was raised by Rocky Mountain Power about filing post-hearing briefs. Are there any objections to filing post-hearing briefs in this matter? Seeing none, we'll grant the motion of Rocky Mountain Power, file post-hearing briefs. I'd like to talk just briefly about a schedule on post-hearing briefs. We could wait till the end of phase one to do that if you prefer, but let me tell you, just our preference as a commission, I think, is we would like to have the parties file a post-hearing brief as to phase one of the hearing in January. And we propose, I've looked at the schedule with the testimony and the other hearings. We've proposed, we think, a January 30th date to file a post-hearing brief on phase one of the hearing on revenue requirement cost of capital. We can talk about other post-hearing briefs. I would anticipate we'd file one more brief on phase two and phase three after the end of phase three. But how do you feel about that? Or want to have any discussion about that issue, about filing a brief on phase one by January 30th? Any objections to that? Okay, we're good with that. Commissioners are good with that. Okay, that's what we'll order. We'll order if hearing, after phase one hearing concludes here in December, you'll have until January 30th to file a post-hearing brief on issues raised in phase one. Okay.
Pardon me, Chair
Please.
Fenn, I would like to
Yes.
raise an issue concerning the length of briefs that could be filed on phase one. The DPU's recommendation is that the briefs be limited to 10 pages. I have not had a chance to ask the other parties for their input on this, but I would like to raise that as an issue for consideration before the order is issued on the briefs.
Okay, thank you. Appreciate that. Let's have any discussion on that. Yes, Mr. Muscombe.
Yeah, the company would object to that, particularly such a short length. And the reason being is each of the other interveners kind of only have the issues to brief that they've dealt with. The company, of course, has to respond to every issue because it's its petition. And so I think it's in a little bit of a different position, but there's so many issues in this phase, I just don't know how we could do anything that'd be useful to the commission and limit it to only 10 pages.
Pardon?
Go ahead.
If I may, I believe I said 20? I said 10. I was thinking 10, sorry.
Some of us can barely begin to write after 10 pages. It takes us a while to get going, so.
I was
okay.
dreaming.
So-
Thank you.
So 20 pages, and I turn to you for your comments on that.
It's the same concern that there are more than 20 issues. That's less than a page per issue. I mean, if I were to guess what it would be, I would guess like 40 pages, but I mean, we realize that the longer it is, the less attention is going to be paid. So I mean, I don't think that we're intending to file hundreds of pages, but I just am very nervous about all parties being able to file similarly length papers, because that means the company is inherently limited.
You know, War and Peace was one of my favorite novels, so I have no problem with reading a long brief. And I appreciate Ms. Schmidt's concerns about that, but my inclination is we allow people to brief the issues as they see as necessary. And I certainly see some interveners may be able to do it within 20 pages. You may be able to do it within 20 pages, but I'm inclined to not put a limit on briefs.
Yeah, I agree with that. I also take Mr. Moskin's point personally that if they're over long, my attention span's not quite as long as Chair Fenn's, so I'll just warn you in advance.
It has to be a scintillating plot line, though, for me to keep my attention span. So, I think we'll not put a limit on pages but appreciate your raising that, Ms. Schmidt. The next issue I want to just talk about preliminarily is with respect to Phase 3 of the hearing. We will consider excess liability insurance and wildfire mitigation issues in Phase 3, as you know. But there is mingled throughout the testimony filed prior to the commission establishing a Phase 3 hearing, significant discussion of insurance issues and wildfire mitigation issues. And so I want to ask how the parties want to handle that, whether they want to defer all questioning on those issues and discussion and testimony until Phase 3, call the witness again to address those issues in that portion of the hearing, or whether they want to allow that testimony to come in here. I would say with respect to the insurance issues and the wildfire mitigation plan that has not been approved by the commission, that seems to me to be something clearly we ought to defer to Phase 3. One possible exception would be parties have raised with respect to the 2022 approved wildfire mitigation plan that wildfire mitigation costs were incurred that exceeded the amount in rates, and so those costs were accrued in a balancing account. And so I understand that amount requested by Rocky Mountain Power is close to $21 million. Is that correct? So do the parties want to consider the cost pursuant to the 2020 wildfire mitigation plan here in Phase 1 and that $21 million, or do you want to defer that to Phase 3? Parties want to comment on that? Mr. Moskin?
Yes, Mr. Chairman, on behalf of the company, you're correct. It was our intention to defer to Phase 3 all topics other than the incremental costs related to the prior approved mitigation plans. So that was our limitation, as those were going to be the issues that we planned on discussing in this phase and deferring all others. But of course, we will abide by any commission ruling.
Yeah, let's see what others say to that. Ms. Schmidt?
Thank you. The division did not, or the division would like to raise a concern with regard to that. It was somewhat unclear as to exactly what was going to be in Phase 3, so I would like to, can I say lightly object to that? Also, I'd like to note that in the cost of capital phase of this Phase 1 hearing, there will be some mention made to wildfire and how that affects risk and cost of capital issues. And I'd like to be permitted to address that in this case, depending upon the commission's wishes and the comments of the other parties.
So I don't think, given the comprehensive nature of this proceeding, that we can have absolutely no reference to wildfire mitigation plans or costs or even insurance issues during the pendency of Phase 1. So the issues that come in will be part of the record. It'll be part of what we consider in when we issue an order. I just want to, I'm trying to manage the hearing. I want to defer as much as possible on those issues to Phase 3, but I do think that the company raises a good point with respect to Phase 1, because we are talking about two distinct, separate issues here, and I think you could consider the issues with respect to the approved plan and the costs, and whether those costs were prudently incurred and your objections to them. But I want to see what others say to that, have to say to that. Mr. Morty, it looks like you want to say something about that.
Yes, and with the approved plan, there's $9 million of, in controversy that we believe should be moved to Phase 3.
Why do you think it needs to be moved to Phase 3 rather than covered in Phase 1?
Because it is connected with the second unapproved plan.
Okay. Mr. Moskin, do you want to respond to that?
I'm trying to think what costs we have that are not tied to the approved plan, because in theory, we were trying to seek the incremental costs for the approved plan. I'm happy to take a 30-second break and
Please do
discuss
that.
with people that actually know what's
Please.
going on, if that would help.
We'll take a 30-second break, and I'll talk about with
All right, thank you.
the commissioners. Let's go to Mr. Moskin first.
Thank you, Mr. Chair. The company agrees that in this phase, Phase 1, it should be limited to incremental costs related only to the 2020 approved plan. So if there's a dispute with the office as to whether some dollars were related to 2023 or subsequent plans, that should be deferred. But if, irrespective of when the dollars were spent, if they were spent related to the 2020 plan, that is what we believe is in this case. I believe the $9 million referenced, we don't dispute, goes into Phase 3 if we're talking about the same thing. But just to be clear, if it's related to the 2020 plan, we have it in this phase.
Mr. Moore, how does that sound to you?
It's actually 9.6 million. We will need to address that because we haven't rebutted that in the testimony in this phase. This amount was identified by OCS witness Donna Ramses, our revenue requirement witness. I think Rock Mountain Power said that if there's a dispute, I don't think there's a dispute. I think, Mr. Moskin, would you agree with me there's 9.6 million that is, should be in Phase 3? I didn't quite understand you.
I think that, yes, I believe we're all on the same page that the 9 million or 9.6 million is part of Phase 3 because that is not part of the 2020 plan expenditure.
Okay. Anybody else? Ms. Schmidt, anything else you'd like to say?
Yes, to the extent that a party did not address some of these issues in its testimony for this phase, and it is precluded from bringing, to the extent as possible, related matters before the commission in this phase, I would note that there could be prejudice to a party for that. As to the 9.6, I do not believe that there is a dispute as to the amount. However, I would need to check that. Plus, there are many issues that seem intertwined that at least the division believed would be addressed in phase 3. So the division is concerned about being required to address some issues which may be unknown at this point or unclear at this point in this phase and being precluded from addressing them in phase 3.
Okay, so here's what we're going to do. We're going to consider the issues in phase 1 as to the approved plan. It's part of revenue requirement. The dollars there would be part of revenue requirement. We will not preclude, if you have moved forward with your testimony and there are other issues that you have not fully addressed, we're not going to preclude anybody from raising these issues. We don't want to relitigate the whole matter on the 2020 plan, but to the extent that the issues on, they're kind of intermingled to some extent. And so we will have several days of hearing in phase 3 on wildfire mitigation costs. The $9 million, it was referred to, 9 point whatever it is, will come up there. And to the extent you have rebuttal or other comments to make in phase 3, you can make those. We won't be issuing a separate decision after phase 1. So we want to have a full and complete record, and we'll allow the parties, if they think they need to supplement something because they weren't prepared, thinking that no wildfire mitigation issues were going to be considered at all in phase 1, and you feel like those need to be raised in phase 3 because you didn't adequately have an opportunity to do so in phase 1, that will be fine. Everybody okay with that? Any
Thank you.
objections? Seeing none, that's what we'll do. Okay. I have one just comment about get your preference on the flow of this hearing. We'll plan on, if anybody needs a break, we'll request one and we'll take a break for a few minutes. But we're going to plan on 10 to 15 minute break, depending on the testimony in the morning, one in the afternoon. Now, a question of council and the parties is whether a 1 hour lunch break is sufficient, or given the complexities of going to get lunch, whether you need an hour and a half break, what you prefer. We can go either way on that. Mr. Moskin?
My uninformed gut reaction is 1 hour, just to shorten the days. I know there was concerns about, are we going to spill over, but that's not a thing I'm laying across the tracks for.
Okay, well, anybody?
I believe 1 hour would be sufficient.
Okay, let's plan a 1 hour break. If after a couple of days you decide, man, we couldn't find any place to eat, we need an hour and a half,
Then I'll crawl back across the tracks.
yeah, that's right. Yeah, you can come back and change your mind. Okay, we're about ready to call a first witness,
Oh.
but yes, but I wanted to see what other matters people had, and then I have one other just procedural matter. Ms. Schmidt.
Thank you. You might be already planning to address this procedural matter, but on Friday, the division filed a motion seeking leave for its witness, Mr. Davis, to appear telephonically.
Okay, yes, I do want to address that. We can certainly have Mr. Davis appear telephonically. I want to say something with respect to, well, let's talk about that first of all. Are there any objections to Mr. Davis appearing telephonically? Okay, so ordered, he can do that. With respect to, there's been some question about witnesses who are not be able to be present there was a discussion about whether we would record confidential matters. We will not, okay? We're not going to have a recording of when we have confidential matters that will close the hearing. We'll do so pursuant to Section 54-4-204, and ask people who've not signed the protective order, confidentiality order, to clear the courtroom. But we also will not have those portions of the hearing recorded. I have concerns about that, whether we can maintain control over those confidential portions, and I don't want to have any potential damage to competitive information. So that's how we'll handle that. Okay, any other? Yeah, if so, there's a witness who's not present. Well, it is live streamed, correct? And you can listen to it live if you're not in the courtroom, but you can't record it. Don't record it. And we aren't recording it. Okay, any other procedural matters before we begin? All right, just one. It's no big deal, but I'm the new kid on the block, as you all know here, and I come out of a background where years ago I was a judicial clerk, and I have a great deal of respect for the process that's used in sworn proceedings. So we're going to just handle the swearing of witnesses a little differently than perhaps has been done in the past. This is a judicial, or at least a quasi-judicial proceeding. And so we're going to administer the oath to tell the truth pursuant to Section 78B-1-143. So how we'll do this is a party will identify their witness, and they'll come up and stand, raise their arm to the square, and I'll administer the oath. The oath ends, so help you God. If somebody has an objection to that, there's an alternative oath and code that I can administer, but I'm going to leave that to you for you to tell me about your witness if they want to have an alternative oath administered. Okay? So, with having said that, are we ready to proceed? Okay, Mr. Moskin, you can call your first witness, please.
Thank you, Mr. Chairman. Rocky Mountain Power calls Mr. Richard Garlish as its first witness.
Mr. Garish, will you raise your arm to the square? Do you solemnly swear that the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. You may be seated. Please proceed, Mr. Moskin.
Thank you. Good morning, Mr. Garlish. Would you please repeat your name for the record and state your position with the company?
Yes, my name is Richard J. Garlish, or Dick Garlish.
Could you spell your last name?
Yep. Garlish, and I am the president of Rocky Mountain Power Company.
Have you ever provided testimony to this commission before?
Not to this commission.
That being the case, I wonder if you wouldn't mind giving just a very short sketch of how you came to be in the position that you're in at this point.
Sure. I attended the University of Montana Law School. After graduating from law school, I was a clerk to Sam E. Haddon, Federal District Court Judge for the District of Montana. And then I began my career in utilities at Northwestern Energy, where I held a number of positions in the legal department. From there, I moved to the Idaho Power Company, and I held several senior legal and non-legal positions. And then I was at Peak Reliability, which was formerly the reliability coordinator for the Western Interconnection for about 3 years. I came to Pacific Core and Rocky Mountain Power about almost 5 years ago, January 2nd. For the first part of my time there, I served in the role as general counsel, and then general counsel and government affairs, and then ultimately president last May.
Okay, thank you. Mr. Garlish, did you cause to be filed in this proceeding direct testimony?
Yes, I did.
As you sit here today, are you aware of any errors or corrections that need to be made to that testimony?
No, I'm not.
If I were to ask you the same questions that are set forth in that direct testimony, would your answers be the same as they are recorded in this document?
Yes.
Rocky Mountain Power moves for the admission of the direct testimony of Richard J. Garish as its first exhibit.
Is there any objection to the receipt of that testimony? Seeing none, will be received.
Thank you. Mr. Garlish, did you have a chance to prepare a summary of your testimony that you could share with the commission?
Yes, I did.
Please do so.
Good morning, Chairman Finn, Commissioners Harvey and Clark. I am the president of Rocky Mountain Power, and I appreciate the opportunity to address the commission today and introduce the 2024 general rate case. To support our filing, the company has sponsored over 20 witnesses to date who are experts in their respective fields to provide the detailed and supporting evidence regarding the company's proposal and drivers behind each proposal. Neither is this summary or my pre-filed testimony intended to provide granular detail about any individual component of the company's request. For that information, I'll refer the commissioners and the participants to each respective expert. I would like to very generally address the company's filing and again thank not only the commission and the staff but all the stakeholders for coming to engage in this process. As I've done in my direct testimony, I want to highlight a few points the company will discuss during this proceeding. First, Rocky Mountain Power serves customers with a vast integrated system of generation and transmission, the system that spans 10 states and serves customers in six of those states, connecting the West. Balancing the needs of customers across a vast territory is not a simple matter. In Utah alone, the company serves over 1 million customers and provides 78% of the electricity sales in the state. Providing safe, reliable, and efficient electric service to these customers requires the company to constantly maintain, upgrade, and as necessary, expand the service and the system to provide for the needs of its customers. Those activities are not free and they are not always inexpensive. The company has to incur costs to improve its physical system and to provide customers with the level of service they deserve. Balancing the need to maintain and expand the system to satisfy the growing demand while minimizing customer rates is a difficult challenge, particularly in an inflationary environment like the one we have existed for the last few years and continues through to today. Specifically, the company's actual costs have increased significantly since its general rate case in 2020. Through the case at hand, the company only requests to cover its fairly and prudently incurred costs. Notwithstanding any perception by some, we don't seek to increase the company's profit level or recover unnecessary costs. To mitigate increasing costs, the company made several proposals. First, the company has sought not to increase its ROE, even though the relevant factors could justify such an increase. Second, the company has also delayed implementing some of the cost and rates so as to more gradually implement rate increases, even though the company continues to incur many of the same costs. As I believe the commission will see from our various witnesses who testified during this proceeding, the company has acted reasonably and prudently to manage capital expenditures, operating costs, and external factors to the extent they are within our control to provide the service that we are required to provide. Very briefly, the drivers pushing the company into the rate case at this time are increases in net power costs outside the company's control, significant capital investments in transmission projects such as the Gateway South and Gateway West projects, addition of renewable resources, and costs to address growing wildfire risks and increased insurance costs. I understand that the Commission has moved the topic of wildfire mitigation costs and excess liability insurance to Phase 3. Oh, yeah, sorry. I got going there, didn't I? I'm sorry. I'll try to be slower. I understand that the Commission has moved the topic of wildfire mitigation costs and excess liability insurance to Phase 3 of this proceeding. As such, I do not intend to focus the Commission on wildfire or insurance issues at this stage of the docket. Nevertheless, as reflected in my testimony, I must note that wildfire impacts, increased insurance expenses are not issues only faced by PacifiCorp in Oregon, Washington, California. Rather, this is an industry-wide issue being faced by utilities and co-ops throughout all the states, especially western states.
Mr. Garish, can I
Yes, sir. Yes, sir.
a second? Do you intend to testify in Phase 3?
necessary.
What I was gonna say is if you don't, I want you to feel like you can say whatever you feel like you need to say about those issues that'll be covered in phase 3 in your introductory remarks. If you're gonna testify in phase 3, then I would say hold them. But I you know, do we know?
I think likely that Mr. Garish is here only for phase 1.
That's what I anticipated.
Right.
You filed one round of testimony, and I figured you were going to be the lead witness for the company and probably not appear again. So you feel free to say what you want to say about those issues because we don't anticipate you returning for phase 3.
Thank you, Mr. Chairman. I appreciate that. So let's start where it was. As such, I do not intend to focus the commission on wildfire insurance issues at this stage of the docket. Nevertheless, as reflected in my testimony, I must note that wildfire impacts and increased insurance expenses are not only issues faced by PacifiCorp in Oregon, Washington, California. Rather, it's an industry-wide issue that's being faced by utilities throughout the West as well as co-ops in the states themselves. Due to the pressures on industry from the wildfire risk, the company reasonably believes that it may simply become unable to purchase commercial insurance at all, or at least on reasonable terms in the near future. For that reason, through the adoption of the Insurance Cost Adjustment, or ICA, the company has asked the Commission to allow it to take an initial step towards transitioning to a self-insured system, which the company would bring to the Commission for approval at a future time. These challenges are being faced by utilities again throughout the United States and are not occasioned by a single fire or single set of fires. I also note in my pre-filed testimony that utilities such as PacifiCorp are experiencing increasing threats to credit ratings due to market risks such as price volatility and inflation, delayed or denied cost recovery, and wildfire and insurance risks. PacifiCorp currently has a BBB+ rating. I noted in my testimony the company is at risk for being downgraded to a BBB- over the next 24 months if these risks are not addressed. It's important for all parties and the Commission to understand that putting the company in a position that forces a downgrade in its credit rating only increases costs, which jeopardizes the stability of the company and harms customers. If the market perceives that Rocky Mountain Power is operating in an atypical risky environment, the generation, distribution, and transmission upgrades and the capital to get them that parties agree are needed for our system will simply cost customers more and result in the company being less able to maintain and upgrade the system, including in Utah, at a time when power demand is on the rise. I don't think the Commission needs to take testimony to appreciate our economy is growing at a record pace, and a reliable electric system is essential for furthering Utah's economy. As the Commission hears testimony from all parties, I ask that it consider both the short and long-term consequences of the positions and proposals that all of the parties offer. If the changes would result in a riskier environment for a utility to operate and impact the service to customers, in the short, middle, and long term, I'd urge the Commission to avoid those outcomes. This is not important for the company, but it's also important for our customers and our state's economy. Thank you for your attention to our pre-filed materials and the testimony that will be presented over the next 2 weeks and in future phases of this proceeding. With this, I will conclude my summary.
Thank you. Mr. Garish is available for cross-examination.
Let's go, I'm proposing to go in the order of the division and the office, and then we'll let interveners as they have questions. So, Ms. Schmidt, turn to you first.
The division has no questions for this witness. However, the division requests a brief break before the company's next witness goes on.
Okay, well, all right, we'll see what other cross-examination we have, and then we'll consider that break at that time, see what time where we are in this schedule. Mr. Moore.
The office is no cross, thank you.
Okay. Ms. Kavalia?
Caviglia. The G's silent is like lasagna.
Now that's going to help me. Okay, do you have questions?
I have no questions on behalf of Walmart, thank you.
All right, so instead of going through everybody individually, let me just ask, who has cross-examination of Mr. Garish? Any of the, all right, Mr. Harvey has a question. Oh, I'm sorry.
No,
Yes.
thank you, Mr. Chair. I was actually just going to clarify that while we had reserved cross-examination time for Mr. Garish, the UTLCG does not have any questions of this witness.
Okay,
Thank
thank
you.
you. Thank you very much. All right. Let's go to Commissioner Harvey. His question.
And feel free to defer to other witnesses if you would like, and I can bring these up later, but you had mentioned them, so I wanted to review some of them. So with respect to the EVA cost increases that you've mentioned, what would you see as the major driver of EVA costs increasing?
Commissioner Harvey, could you clarify just so I understand? Are you talking about, I was speaking in my testimony about the rate mitigation mechanisms, or are you talking about something more specific as to the EVA?
Okay, so you're limited only to the mitigation.
I just want to make sure I understand the question that you were asking.
Well, I was asking deeper than that, but if you're not addressing that,
I would refer that to Ms. Stewart.
okay, that's fine. But then in terms of the deferred costs, any cost that is deferred in terms of the rate making, if it's in a balancing account, if it's a balancing account type of cost, RMP would still eventually collect that, correct?
I will refer that question to Ms. Stewart, but I will note that my understanding of that EBA account is that we are deferring it to the EBA, but we will have to go through a proceeding like this one to establish that those costs are in fact recoverable. So I wouldn't say it's a guarantee that we would recover it based on my understanding, but again, I would defer to Ms. Stewart to talk about the mechanics.
Then assuming it was prudent, there would be interest associated with that account that ratepayers would pay, correct?
Again, that's a level of detail I'm not prepared to address. I'd refer you to Ms. Stewart.
Okay. With respect to the wildfire issues that you mentioned, can you clarify for me, and again, this may be another witness, but has RMP provided Utah-specific risk justifications for those insurance increases, or simply referred to the industry averages?
I'm going to defer that to Ms. Stewart and Ms. Kobia.
Okay. Then with respect to the credit rating, talk about there's a potential, depending on the outcome of this case and other things, that the company might be moved from a BBB+ to a BBB-.
Yes, sir, that's correct.
Can you tell me at current levels of interest, how much of an interest impact that would, in terms of the percentage that would be paid on debt?
I'd have to refer that to Ms. Kobia for an exact number calculation.
Okay. And then, just so it's on the record, Pacificor RMP only has one shareholder, correct?
That is my understanding, but I'd again refer that to Ms. Kobia because there are different types of, we do sell our debt is traded, so I will.
All right, well, the debt, but in terms of equity, shareholder, there's only one, right?
That's my understanding.
And then in terms of the debt, has Pacificor ever had an issue of debt that they were not able to fill?
Not to my knowledge, but I would defer you to Ms. Kobia, who would be able to answer that more fully than I can.
Okay, thank you. That's all I have.
Commissioner Clark, do you have any questions?
Yes, thank you. Good morning, Mr. Garish.
Good morning, Commissioner Clark.
I want to just learn a little bit more about your dividend policy and its current the suspension that you mentioned in your testimony. What years does that apply to? Or in other words, when did the suspension begin?
It is for 5 years. I refer to Ms. Kobia because I'm not sure. I think it was 2023, but it may have been 2024. So I'll refer to her for the exact date.
Okay. And then, are you aware of whether or not the other operating companies in the Pacific Corp system have similarly suspended dividend payments to the parent?
I can't speak for entities like Nevada Power or those. I don't have any knowledge of that.
Those are all my questions. Thank you.
Thank you.
Mr. Garish, thank you for your testimony. I just have a couple of questions with respect to your statement about possible downgrades by Standard & Poor's and other rating agencies. Excuse me?
Sorry, you said I just have a couple of questions with respect to your statement about possible downgrades
By Standard & Poor's and other rating agencies. Okay. So you're at a BBB+. You talked about a possibility of a BBB- rating. That would be 2 downgrades in your rating. Is that correct?
Yes, sir.
So have you had discussions yourself with the rating agencies about possible downgrades?
I have not, but Ms. Kobia has had direct conversations with them.
Okay. You made a comment that both rating agencies have indicated that regulatory support will play a major role in their ongoing rating assessments and actions. What have you learned about that?
Yes, so my understanding through industry, trade, press, and conversations with Ms. Kobia is that as the credit, let me back up. The utility business is inherently, it was always a risky, capital-intensive business. And with the threat of extreme weather of all kinds and the upward inflationary pressures and the cost of insurance, it's become more risky. So generally speaking, and following kind of basic laws of economics, the money, credit rating money, likes to go where there's least risk. And there are a number of factors, both general and specific, that are considered when assignment of a credit rating. There's general industry trends like the impacts of wildfire, the transition to new technologies, investments in capital upgrades, and increasingly more often a look by the rating agencies to the extent that regulatory commissions are supporting capital investment, extreme weather mitigation as part of, along with other factors like wildfire, kind of from a general perspective, like an industry perspective, and then specifically how each company, what their experience is, either with wildfire or regulatory support in terms of being able to recover prudently accrued costs consistently.
It's your understanding that a BBB- credit rating is still considered investment grade, is that correct?
It is correct, but it is not, it's and I'll defer to Ms. Kobia exactly, but it's getting closer to non-investment grade. And just like your credit score at home or consumer, a shift down to just above non-investment grade has a significant cost. It will impact our ability to make the needed capital investments we need to make, do the wildfire mitigation, and provide the service that customers expect. It will increase costs.
Okay, thank you. With the questions were asked by the commissioners, or any follow-up questions anybody has? Okay.
Thank you, Mr. Garish.
There's one moment.
And if I might, while Rocky Mountain Power Council is conferring,
Please.
the division has resolved its issue and no longer requests a break after this witness.
So many people here are disappointed. Okay,
Thank you.
all right.
Just one clarifying question. Mr. Garish, you were asked a question about the dividends and who is or isn't and when it started. just clarifying, is it your understanding that that suspension applies to the Pacific Corp entities as a whole?
Yes, that is my
All
understanding.
right, thank you.
Okay, thank you. Seeing no other questions, Mr. Garish, thank you for your testimony. You may be excused.
Thank you.
All right, Mr. Moskin, you can call your next witness.
Thank you. Rocky Mountain Power calls Joelle Stewart as our next witness.
Ms. Stewart, will you raise your arm? To the testimony you are about to give in this matter pending before the Public Service Commission of the State of Utah, will it be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may be seated. Mr. Moskin, the witness is yours.
Thank you. Good morning, Ms. Stewart. Would you please repeat your full name for the record?
My name is Joelle Stewart.
And what's your position with the company?
I am the Senior Vice President of Regulation for Pacific Corp.
And how long have you had that job function? Ish.
Since November 2021.
Okay, excellent. In this proceeding, Ms. Stewart, did you cause to be filed direct testimony, amended direct testimony, and rebuttal testimony?
Yes.
Are you aware of any mistakes or corrections that need to be made to that testimony?
No.
If I were to ask you the same questions that are set forth in those pre-filed sets of testimony, would your answers be the same?
Yes.
With that, Rocky Mountain Power moves for the admission as its second exhibit of the direct, amended direct, and rebuttal testimony of Ms. Stewart.
Were there exhibits attached to that?
That's what I was just turning to
think you-
look. That's what I was just turning to see.
Did you have any exhibits attached to any of your
No.
testimony?
I
I don't
did
think
not.
so.
Okay. So the motion is to admit all the pre-filed testimony of Ms. Stewart. Is there any objection to that? Seeing none, the testimony is admitted.
Thank you. Ms. Stewart, did you have an opportunity to prepare a summary of all that testimony that you could share with the commissioners?
Yes, I do.
Would you please do so?
Yes. Thank you. Good morning, Chairman Fenn, Commissioner Clark, Commissioner Harvey. As discussed in my pre-filed testimony and the pre-filed testimony of the other company witnesses, Rocky Mountain Power is requesting approval of a revenue requirement increase of $330.2 million, or about 14% in this general rate case. The proposed rate change in this docket is largely attributable to significant increases in net power costs since the company filed its last general rate case in 2020, as well as capital investments in transmission infrastructure, investments in renewable generation resources, wildfire mitigation, and commercial insurance premiums. Pacific Corp understands the impact that a rate increase has on customers, especially given the economic challenges faced over the last several years. This is why the company proposed to mitigate the rate pressures by trying to extend the recovery period for net power costs, as well as hold flat its return on equity in this case, despite changes in the capital market conditions driving up the cost of equity since the last rate case. The company has always sought to be responsive to our customers, and we work to balance the interest of customers and the company. For this reason, we filed an amendment to our application in August of 2024 to further mitigate the near-term impacts of rate increases. We propose to eliminate the second-step rate change associated with net power costs, which will increase the deferral balance for net power cost recovery through the Energy Balancing Account, or EBA, but eliminate the compounding effect of setting a higher base net power cost in rates while also recovering balances in the EBA. As such, the proposal should mitigate the rate increases for a period of time, absent significant new spikes in commodity costs for power. With respect to the significant increase in net power costs forecasted in the case compared to the last general rate case, the upward trend is largely attributed to increases in regional power and fuel prices. However, the company has and continues to make long-term investments, such as in transmission and wind resources, that respond to changes in the industry and allows the company to mitigate the increase in net power costs. But these investments will not eliminate the volatility of net power costs. Further, the company's participation in the Western Energy Imbalance Market has realized savings for customers, and the company expects its participation in the extended day-ahead market will realize additional savings in the future. Another driver of this rate case is the company's capital investments. After extensive analysis, the company is investing approximately $7 billion of new capital through calendar year 2025 in transmission, renewable energy resources, wildfire and safety mitigation measures, and other investments. The company does not make decisions to move forward with new major capital expenditures lightly, and as the team of witnesses that follows me will explain, we undertake extensive analysis to evaluate the alternatives and risks known at the time of the decisions before moving forward. These investments are necessary and prudent and will allow the company to continue providing safe, reliable, and affordable solutions for its customers. The last cost driver of this proceeding that I'll note is excess liability insurance costs. While the insurance costs, along with the 2023 wildfire mitigation plan, are subject to Phase 3 of this proceeding, in this phase, we will address the incremental costs already expended by the company to implement its 2020 approved wildfire mitigation plan. Company witnesses, Mr. Alan Barrett and Ms. Shelley McCoy, will address the incremental costs associated with wildfire mitigation in this phase. I would like to note that the proposed wildfire mitigation actions are necessary for public safety and to prevent unsustainable risk. Further, failure to fund insurance and mitigation efforts will jeopardize the viability of company operations, which will ultimately further increase costs to customers. Next, my pre-filed direct and rebuttal testimonies address the importance of the EBA that is currently in place in Utah. As noted in testimony, I'd like to emphasize the continued need for the EBA and its significant benefit to customers and the company. The EBA has been an approved method of recovery for net power cost in Utah for many years. The Commission and the Utah Legislature have been supportive of the EBA during that time, recognizing the benefits to customers of using the EBA and recognizing numerous factors that make the EBA important for the company and its financial condition. Before the EBA, customers either overpaid for net power costs without a refund, or the company over-recovered its net power costs, which markets view as imposing risk to healthy utility operations. It is for this reason that mechanisms like the EBA are common across the U.S. The EBA tracks and recovers net power costs, which are volatile due to the external market forces beyond the company's control and thus difficult to forecast in general rate case proceedings. Additionally, the EBA has reduced the need for more frequent general rate cases and allows for costs to be recovered closer in time to when they are incurred, reducing regulatory lag. If the EBA is eliminated, as the DPU proposes, there will be a higher increase in customer rates of approximately 26% to put the full forecast of net power cost into rates. Absent the EBA or this significant increase to incorporate the full forecast into rates, the company would not be provided a fair opportunity to recover its costs and would face significant financial risk. Many of the interveners' complaints about the EBA revolve around the size of the EBA and the associated allegation that the EBA allows the company to prioritize its own interest over the interest of customers. This is simply not true. First, the size of the EBA does not hinge on actions by the company. These costs are the result of a number of market factors outside of the company's control. The company is not making a profit off of the costs recovered through the EBA. The EBA includes an extensive audit and prudence review process before the company is authorized recovery. Thus, company management has no incentive to try to doctor the EBA recovery cost. The company simply utilizes the EBA to recover actual costs it has incurred for providing this essential service to our customers. Any contention, such as that made by Western Resource advocates, that the company delays resource acquisition or capital investment decisions due to the EBA is untrue and mere speculation with no support. Company witness, Mr. Rick Link, specifically addresses that resource acquisition decisions are not influenced by the existence of the EBA. Instead, the company is continually seeking the investment approach that will result in the lowest cost for customers while providing the system upgrades our state's growing economy needs. There is simply no basis for changing or eliminating the EBA at this time, nor is there any reason to open a new docket to explore alternatives to the EBA. There are several other important issues I address in my testimony that I would like to briefly highlight for the Commission. First, the proposed approval of the Insurance Cost Adjustment, or ICA, is merely a way to isolate insurance costs and rates while the company is evaluating a transition to self-insurance that may allow us to better manage premium costs while ensuring ongoing coverage. We are not seeking to adopt a specific new insurance mechanism in this proceeding. As the Commission briefly heard from Mr. Garish, the company may soon be unable to acquire reasonably priced commercial insurance. Approving the ICA now would allow for an easier transition to self-insurance in the future, if and when needed. But let me be clear, approval of the ICA in this proceeding does not increase or decrease the amount of insurance expenses and customer rates. Second, without providing an alternative, the division contends that the SO factor, or system overhead factor, which has been the standard for several years to allocate insurance costs, should no longer be used. The SO factor is calculated using system overhead, and these expenses support the overall system involved in serving customers across the company's service area. Moving away from the SO factor and the 2020 protocol in this case is unreasonable. The company's insurance coverage benefits all states, just as the company's generation, transmission, and distribution resources benefit our entire service area as well as that specific to Utah. Maintaining insurance is a necessary and prudent cost of doing business as an integrated utility, and using the SO factor remains the most reasonable allocation for the current costs, consistent with the 2020 protocol. Third, Utah Clean Energy claims that the Commission should evaluate and consider an alleged imbalance of costs and risks between customers and the company regarding climate change. What UCE fails to recognize is that the company has to balance a number of risks, costs, and policies, including the cost impacts of adding a significant amount of new investment that would be required to replace thermal generation, as UCE seems to desire. The company is actively working to address climate change in ways that it can, while still considering reliability, affordability, and responding to state and federal policies. Fourth, compliance cost associated with Washington's Cap and Invest program should be recovered as a required cost of serving customers. The program imposes a legal obligation on the company to acquire greenhouse gas, or GHG, emission allowances for generation from the Chehalis natural gas plant, which is located in the state of Washington. These allowances are a generation tax that is directly correlated to the generation produced from Chehalis, which is a system resource serving all of Pacific Corp's customers, including those in Utah. Generation taxes akin to these greenhouse gas allowances are not uncommon. All of the company's generation resources incur various types of environmental compliance costs and generation taxes, many of which are imposed by the state where the resource is located. Interveners have asserted that the cost of these greenhouse gas allowances should be removed from customers' rates because the Cap and Invest program is a policy adopted by the state of Washington. But as explained in greater detail in the testimony of Mr. Ramon Mitchell, even after accounting for the cost of greenhouse gas allowances required under the program, generation from Chehalis reduces power costs to Utah. Interveners insist that Utah customers should not have to pay the full cost of Chehalis generation, but if Utah customers are going to receive the benefits of Chehalis, then it is just and reasonable that Utah customers pay the cost of Chehalis generation, including the allowances. The company should not be penalized for complying with Washington law. Finally, I would like to address the allegations made regarding the messaging of the company's rate mitigation efforts. As I explained in the June 2024 filing, the company proposed to implement the rate increase related to net power cost over 2 steps. Then in our August 2024 amendment, we revised our mitigation approach to eliminate the second step rate change associated with net power costs. The company has been clear about what the amendment seeks to do, and it has not intentionally perpetuated any messaging that would obfuscate that change. We have clearly stated through pre-filed testimony and company press releases that the EBA would be used to recover the differences between the level of base net power costs and actual net power costs. The company submitted the amendment to be responsive to customer concerns about the extent of an immediate rate increase and to try to implement the rate increases over a period of time. There is no other motive for the company to delay our own recovery of costs. Additionally, any perception that the company was or is charging excessive amounts for its services is incorrect. Net power costs arise out of costs the company either has actually incurred or will incur during the test period to provide reliable service to our customers. As such, the company should be entitled to recover those costs. As the Commission listens to witnesses on this topic, it is important that the Commission bear in mind that the company does not earn a profit on net power costs or EBA deferrals, and that includes the carrying charge, which is the cost of financing the cash necessary to pay for the power costs. Rather, the company merely breaks even. Thus, when as here, proposed rate increases are driven by factors outside of the company's control, such as the inflationary effect on fuel costs and materials, the company should have a fair opportunity to recover our prudently incurred cost. For the reasons explained in my testimony and the testimony of the company's other witnesses, I urge the Commission to approve the updated rate increase described in our filing. Thank you for your attention to these admittedly complicated matters, and that concludes my summary.
Thank you. Yes, Ms. Stewart is available for cross-examination. No, thank you.
All right.
Thank you. Good morning, Ms. Stewart.
Good morning.
Does the company recommend that if there are adjustments made to step 1 net power costs that the company proposed would be recovered in this docket, that the company has recommendations about about how the effect of those changes can be addressed?
Can I paraphrase what I think the question is to make sure I am understanding it? But to the extent parties are proposing changes to the forecast of net power cost that we have in this case, is that what you're referring to?
Yes, and if the Commission orders or chooses to order something different than what the company has proposed, how does the company suggest that that difference be handled?
Well, I mean, we've proposed to put in only, a portion, I think about half of our forecast power cost. I mean, we recognize it's a forecast. It's gonna be wrong. It always is. And so we're proposing that, that be trued up through the EBA later and mitigate this first step increase. But in the meantime, by increasing our base net power costs, we will be decreasing those deferrals going forward. To the extent the Commission orders something different, I think we would ask that the full forecast go into rates now, if that is the alternative to elimination of the EBA. Otherwise, we think our proposal is in the best interest of customers. And to the extent there are other parties that have a different forecast, I don't have a response to that.
So what is the company's position with regard to what should be done with the step 1 NPC increase if the commission chooses something else? How will the company seek to recover, if it will, that amount?
I'm sorry, I don't quite understand the question.
I apologize. Let me just start again. The company has proposed that only the step 1 increase be implemented at this point. Is that correct?
Correct.
To the extent that the commission makes adjustments to that net power cost figure in this case, does the company propose that those adjustments be made against the step 1 increase?
Oh, I think I understand. No. Because our step 1 increase is only half of that overall forecast, I think and Mr. Mitchell would be the witness to address more wholesome what the impacts of proposed net power cost adjustments are on the forecast. But to my knowledge, none of the proposed adjustments for net power cost forecast, other than maybe the DPU with the hedging costs, but Mr. Wilding will address those, as well as Mr. Mitchell, which we believe have no validity. Our forecast is only a fraction of, or what we propose to put into rates is only a fraction of our full net power cost forecast. So we would not propose that those adjustments come off of what we've proposed.
Thank you. Moving on to my second area, my co-counsel, Mr. Grecu, will pass out what has been labeled as a DPU cross exhibit. It has not been pre-marked with a letter or numbers. I'll describe it as a true and correct copy of the company's letter to the commission. Just one moment. Yeah.
Please go ahead, let's distribute it, and we'll have everybody take a look at it. And we'll see if there are any-
I'll represent that what Mr. Grecu is passing out is a true and correct copy of the company's letter terminating negotiations to extend the protocol in docket number 23-2035-15 without the service list and with my initials added to the upper right-hand corner. Could we please mark this as DPU cross 1?
Okay, let's do that. Let's see if there's any objections to this, being received. Cross exhibit, BPU cross exhibit 1. Any objections to this, to the BPU's, cross exhibit 1 being
In abstract, no.
You may have objections later after you hear them, but we'll admit it.
Right.
We'll admit it into evidence. Go ahead.
Thank you. So it is correct that the company filed a notice on July 11th of this year terminating the negotiations of the Framework Issues Work Group.
Correct.
Correct?
Could you give us just 30 seconds
Oh, pardon me.
to review this before you ask any other questions? I think that'd be helpful.
Pardon me.
Okay. As long as it takes us to read it. Has everybody had a chance to review this?
Thank you. Do you agree that it is correct that the company filed this notice on July 11th of this year terminating negotiations of the Framework Issues Work Group?
Yes.
So the group has not met to discuss protocol issues since July, correct?
Not general framework issues, yes.
And the notice that the company filed on July 11th contemplates that the company will propose some allocation method rather than seek agreement amongst the states. Is that correct?
Correct. I mean, we are considering what to bring forward.
Thank you. I would like just a moment to move to my next area. I have a few more questions, and Mr. Mitchell also addressed some of these, but I will first submit my questions to Ms. Stewart. If she, of course, wishes, she can defer them to Mr. Mitchell. Isn't it true that under the Washington Cap and Invest program, the more Chehalis generates, the more allowances Washington gets?
Well, we have to acquire allowances for all of the generation from Chehalis. So, I mean, to the extent it is serving Washington as well, which is a system allocated resource, I believe that is correct. At least for the time being, allowances may decrease over time, but I may not be the best expert on the detailed workings of the cap and invest program.
And just one more moment, please. Actually, those are all my questions for this witness. Thank you.
Yes, the OCS has no questions for this witness. Thank you.
I do. Good morning, Ms. Stewart.
Good morning.
I've got two topics I want to address. Let's start with the insurance cost adjustment. You have indicated in your testimony that, and I'm paraphrasing, and obviously you can disagree with me, but that the purpose of the request here is in anticipation of some future insurance mechanism that the company intends to file or request a filing for, right?
Yeah, specifically to incorporate self-insurance into rates.
Right, and tell me how this helps with that.
So if we incorporate self-insurance, which would help us manage costs but still maintain coverage levels, we would want an amount collected into rates that would build a self-insurance reserve balance. And what ideally I'd like to see is that we have an amount currently set in rates, let's say, and I can't remember what it is for Utah allocated right now, say it's $50 million, that we would just continue to collect that $50 million. Our commercial coverage premiums maybe would be within that, but what is left over, say $20 million, would go towards a reserve, and we would be tracking and that collection for self-insurance into a restricted account. But then once you've funded that reserve, you have to cancel the surcharge. You don't want to overbuild that reserve. And so it gives us that flexibility then to cancel it or to manage it within. As you make claims, you may make adjustments to the surcharge. Just having those costs isolated better allows us to manage those collection levels to a specific reserve for self-insurance.
But at present, we don't have a self-insurance mechanism or even a filing to consider with respect to that, right?
Right, not for these costs. We do have other self-insurance and rates.
Sure, but for the costs you intend to manage through the ICA, we don't.
Correct.
Okay. You've indicated in your testimony that a filing about that will be forthcoming. It's possible that the commission may ultimately decline to adopt such a program, right?
That is a possibility, yes.
Yeah. But moving the rates associated with excess liability insurance out of base rates and into this rider, doesn't that create a mechanism whereby the company could, if it chose to, come into the commission between rate cases and seek to adjust the amount that it wishes to recover? or wants to recover for that line item?
I do not contemplate that. That is not our proposal. This is really a way to isolate those costs while we work through potential self-insurance. I mean, it's to the extent we made a separate filing to recover differences, I mean, that would go through its own proceeding.
Right, but that proceeding, if you know, were to happen, would be looking specifically at the costs associated with excess wildfire liability insurance and not at the whole suite of costs that we're looking at in this proceeding, right?
Potentially, sure.
Yeah, okay. Thank you. I'm going to move now to a discussion about the Washington Climate Commitment Act. You and several other witnesses have offered testimony about this. You've indicated in response to one question from Ms. Schmidt that you're not the person to talk about the specific workings. I do have some questions about how it works, and hopefully they'll be general enough that we can both talk about them. I am also not an expert on the specific workings. But let's start with what it is. It is a program adopted by the Washington legislature, what, in 2021, is that right?
That sounds about right.
And it is a suite of laws that's intended ultimately to drive down greenhouse gas emissions in Washington, right?
Well, this was a specific law. I mean, there have been other laws, so I wouldn't call it a suite of laws. I mean, there was, before it, there was the CETA, which is what we have to comply with to meet load in Washington, which is the basis of the free allowances for Washington customers. And I cannot think what CETA stands for, but it was a separate law. But they've had a number of laws related to addressing climate change.
Clean Energy Transformation Act or something along those lines?
Good job, yeah, that's it. Or, I think so. It sounds
sure.
good. It fits the letters.
Right. In your testimony, you refer to the Cap and Invest program. That's part of the CCA, or the Climate Commitment Act, right?
Right, a separate law.
And then there's this separate discussion about CETA, which may or may not stand for Clean Energy Transformation Act. And that is a set of laws that imposes certain portfolio standards for Washington generation facilities, right?
It sets an emission standard, which I believe was enacted before the Cap and Invest law. Yeah.
Right, okay. And the cap in the Cap and Invest is intended to cap emissions, right?
Yes, it's for generation, and I'm not clear on the full extent of it. It applies to, you know, it's much bigger than just electric utilities, but to cap emissions of facilities emissions for facilities within Washington.
Right, and it caps emissions by requiring certain industry participants to track those emissions and then to obtain allowances that match those emissions, right? Just at
simplistically, yes.
Very high level, right? Yes. Let's stay there. I think it's something like one allowance for each metric ton of CO2 equivalent or something like that. Does that sound familiar?
Yes, but I'm
okay.
Not the witness with that depth of knowledge.
Fair. And for an electric utility such as PacifiCorp that operates, you know, carbon-emitting resources like a gas plant, like Chehalis, you have to report the emissions from that plant, and then you have to obtain allowances that match those emissions on an annual basis, right?
I believe so,
okay.
Yes. I mean, the timing of, I know there's a forecast and then there's actuals, and the timing of how all that works, I am not very familiar with.
Okay, but generally speaking, those allowances are acquired at an auction, is that right?
I believe so, yes.
Okay, and the Washington state government, or potentially some arm of the state government, sets the number of allowances that can be sold at those auctions, right?
I would defer to Mr. Mitchell or even Mr. Wilding.
Okay. And the costs associated with compliance is the cost to acquire those emissions allowances, correct?
Yes.
Okay. I have some other questions that maybe get in a little too deep onto the details, and I'll reserve them for some other witnesses, so bear with me. So the allowances, as we've discussed, the allowances have to match the emissions from the unit, right?
I believe so, yes.
Right. And you acquire allowances at an auction, but some of the allowances that you acquire are at no cost, correct?
Because Washington customers are subject to the Clean Energy Transformation Act, where we have to meet load with emissions reductions over a period of time. Yes, they have been given free allowances by the state to offset those costs in light of other costs that they are incurring to meet the CETA law.
So okay, I appreciate the fuller answer than the one I was actually asking for, but no, I appreciate that. But just in terms of the cap and invest portion of the program, those allowances that are associated with emissions that are deemed to serve Washington customers, those are free, yes?
I would defer to Mr. Mitchell or Mr. Wilding. I mean, conceptually, that is my understanding.
Okay, all right. There's been some discussion between you and others who have pre-filed testimony about whether there's any guidance for how to approach the allocation of costs from this in the 2020 protocol, right?
Yes.
Okay. I'm gonna hand you the 2020 protocol here in just a second. I've got some binders that I'm gonna hand up to the commission that has all of UAE's cross exhibits, just so we don't have to keep going back and forth. It will be cross exhibit number 4. I've distributed before the hearing each of the cross exhibits to others, so hopefully that will keep us from having to hand out too many binders.
So the record will reflect that Mr. Russell attended to the commissioners' UAE cross-examination exhibits for the phase 1 hearing. And you've already provided these to the parties, is that correct? Okay.
Yes.
Would you like to lay any foundation for receipt of these? These are not pre-filed exhibits, these are.
No, they are pre-marked, and I haven't pre-filed them, and I'm only going to address UAE Cross Exhibit 4 for the moment. And I'm only going to seek admission of Cross Exhibit 4 at the moment. And I likely won't seek admission of all of them. These are just to keep us from having to hand out exhibits.
I appreciate that. So as to cross-examination exhibit 4 for UAE, is there any objection to that? Will you give you a chance to look it over?
And just to be clear, because I don't think we got it or the email, it's just the 2020 protocol?
Yes.
What number 4 is?
Yes. And specifically, it's the one that was attached to Ms. Stewart's testimony in the 2019 MSP docket, 1903542, I believe.
All right, any objections? Okay, the cross-examination exhibit 4 will be received.
Ms. Stewart, you have indicated in your testimony and your summary today that the Washington CCA is akin to a generation tax. Is that right?
Yes.
Okay, and in your pre-filed testimony, I'm going to ask you to turn to lines, where are they? Lines starting at 215 of the exhibit, which is section 3.1.7.
Yes.
Which deals with miscellaneous costs and taxes. And you've pointed to 2 particular lines. It's this first bullet-pointed line that says generation, or I guess I should point out, line 216 says miscellaneous costs described below will be allocated as follows. And you've quoted this line on 217, generation-related dispatch costs and associated plant will be allocated on the SG factor, right?
Yes.
Okay, let's linger on that for just a moment. One of there are 2 types of costs that are incurred as relating to the Washington CCA. There are the direct costs, the costs associated with acquiring the allowances. And then there's the indirect costs associated with dispatch of Chehalis within the dispatch stack, right?
Right, because the dispatch that stack then incorporates the cost of the allowances or an estimated cost of the allowance.
Okay, and then to put some more meat on those bones, the company dispatches its resources, generally speaking, in a least cost manner. It dispatches its least cost resources first and its highest cost resources last, right?
Right.
Okay, and to the extent that anything causes any particular resource to cost more in that stack, there are associated costs because of it, right?
Right.
Yeah, okay. And so you note, go ahead, is there a question? No, okay, sorry. You note that the CCA, your position is that CCA relates to or is akin to a generation-related dispatch cost that should be allocated on the SG factor. That's your position, right?
Yes.
But again, the costs here are the cost to acquire allowances, yes?
Yes.
Okay. And then with respect to the direct costs, you point to section or the bullet point on line 232. So generation and fuel related taxes will be allocated using the SG factor. That's what you point to in your testimony, right?
Yes.
Okay. And again, the cost isn't directly associated with generation. It's with the emissions allowance that needs to offset generation, yes?
I'm sorry. Say that again.
The cost of compliance is not imposed directly on the generation. It's the result of having to acquire emissions allowances for that generation, yes?
Yes, you're parsing something there that I'm not quite sure I'm seeing though, but.
Okay, fair enough. We will move to section 3.1.2.1, which starts at line 160. This is a provision of the 2020 protocol that Mr. Higgins, UAE's witness, and others have pointed to as saying this provides some guidance. That's correct, isn't it?
Yes, this is what he's pointed to.
Okay. Yeah, I'm not asking you to agree with him. Just that's where we are. Let's look at the second bullet point there for portfolio standards. It says, that starts at line 168, and it says, the portion of costs associated with interim period resources acquired to comply with a state portfolio standard adopted either through legislative enactment or by a state's commission that exceeds the cost Pacific Corp would otherwise have incurred will be allocated on a situs basis to the jurisdiction adopting the portfolio standard, right?
That's what it says.
Okay, why don't we talk a little bit about what this provision is intended to address. In the event that a state adopts a standard that says a certain amount of our resources need to be of a certain type, right? And to the extent that resources are required to be built to address that standard, that this is what allocates the costs associated with those resources, correct?
Correct.
Okay. Is there a state portfolio standard that the company has to comply with that would trigger this allocation?
There are a number of them, yes.
Okay. And do they include the CETA?
They do include the CETA yes, it does include the CETA.
Okay. So in connection with this agreement that the parties have reached and that the commission has approved, in the event that there is some state-approved specific portfolio standard and there are costs associated with acquiring resources to address that standard, everybody has agreed those should be situs assigned to that state, yes?
Right. So to the extent we acquire a new resource, a new solar, renewable resource, the cost of that resource, to comply with a Washington law or an Oregon law, the cost and the benefits of that resource would stay with that state.
Then let's move down to the next bullet point under, with the title State-Specific Initiatives, starting at line 173. And this says, the costs and benefits associated with interim period resources acquired in accordance with a state-specific initiative will be allocated and assigned on a situs basis to the state adopting the initiative. State-specific initiatives include, but are not limited to, the costs and benefits of incentive programs, net metering tariffs, feed-in tariffs, capacity standard programs, solar subscription programs, electric vehicle programs, and the acquisition of renewable energy certificates. Did I read that correctly?
Yes.
Okay, so in the MSP discussions that culminated in this agreement, the parties have agreed that to the extent that a state-specific law or initiative requires the acquisition of things like renewable energy certificates for a state, that the costs of doing so should be assigned to the state that caused those costs to be incurred, right?
Right, for specific programs or compliance to meet the load of that state, yes.
Okay. And two other state commissions that where Pacific Corp does business have addressed this very issue about the Washington Climate Commitment Act and the costs associated with it. Is that right?
You said two?
Oregon Public Utilities Commission has addressed the allocation of costs from the Washington CCA and has the Wyoming Public Service Commission, right?
Yes, they both have.
And they've both concluded that the costs associated with compliance with CCA should be situs assigned because they are more akin to the types of state-specific initiatives we were just discussing than they are to generation taxes, right?
That was their decision.
Okay, thank you, that's all I have.
Yes, Mr. Chairman, the UTLCG does have questions, but I recognize you wanted to take a morning break, and I think this is a good time to do so.
And I think next we'll hear from Utah Large Customer Group, Mr. Jensen.
Thank you, Mr. Chairman. I'm going to have my colleague, Ms. King, bring up a couple exhibits to the witness and the court reporter, as well as the dais. These exhibits were pre-circulated, and Ms. King sent out an email to the distribution list just to put it at the top of everyone's inbox if you'd like to follow along. And while Ms. King's doing that, Ms. Stewart, I just want to make sure you have a couple things in front of you that we'll be referencing during our discussion. The first is your direct testimony, your amended direct testimony, and your Phase 1 rebuttal. And then I'll also be referencing UAE Cross Exhibit 4. I brought a different set of the 2020 protocol, but in order to avoid duplication in the record, we'll reference that exhibit.
Oh, UAE Cross Exhibit 4, okay.
Yes.
Okay, before we proceed, let's just note for the record that Ms. King has distributed to the commissioners and court reporter 2 documents, a motion for preliminary injunction and memorandum of support in Pacific Court versus Laura Watson that was in the United States District Court for the Western District of Washington, and another document about Washington Families Clean Energy Credits. Okay.
That's correct, Mr. Chairman, and when we get to those, I'll reference them, and I brought stickies to attach to them, but they're not working, so I apologize for that.
Well, we'll just mark them. What do you want to call them?
The single page that has a bunch of black on it, that's going to be UTLCG Cross 1. And the motion for preliminary injunction will be UTLCG Cross 2.
Okay. These have previously been distributed to council. Are there any objections to receiving into evidence these 2 documents? Seeing none, they are received. Go ahead, Mr. Jensen.
Thank you, Mr. Chairman. Ms. Stewart, I'd like to start our discussion with your testimony related to rate mitigation. Could you please turn to page 11 of your direct testimony and let me know when you're there?
I'm on 11.
Do you see the question starting on line 239 that asks, is the company proposing measures to mitigate the rate impacts in this case? And your answer is yes, and goes on to describe 4 company proposals. Is that right?
Yes.
One of those proposals is a phase-in of base net power costs through a 2-step change in rates. Is that right?
Yes.
And you discussed this a bit in your opening remarks, but I just want to clarify for the record exactly what's going on here. As described in your testimony, the company's original proposal in this case was to increase base net NPC by $285.2 million on the rate effective date. Is that right?
Yes.
Then, approximately a year later, the company proposed to increase base NPC rates again by another $285.2 million, correct?
Yes.
In the year period between those 2 increases to base NPC, the company originally proposed to track and defer any difference between NPC recovered in base rates and NPC actually incurred for recovery through the EBA, correct?
Yes.
And any deferral in the EBA would be subject to a carrying charge, correct?
Yes.
Because of the company's proposal to track and defer differences between NPC recovered in base rates and actual MPC incurred with inclusion of a carrying charge, the company did not propose to forego any net power costs, correct?
Correct, but recognizing our actuals are subject to prudence review and ultimately collection through an EBA proceeding.
Under this rate mitigation proposal, customers would not actually be avoiding costs, correct?
No, unless to the extent our forecast doesn't materialize, then those costs would never have been collected in rates to begin with.
And so the company's original proposal of rate mitigation is more a matter of timing of the company's full cost recovery as opposed to cost savings for ratepayers, right?
Correct. I mean, we're still dealing with the same cost. It's just the timing of recovery of those costs.
All right, let's turn to how the company's amended application changed this. In the company's amended application, the company proposed to remove the second step increase to base MPC in the amount of $285.2 million, right?
Correct.
Like the company's original proposal, the company would nevertheless track and defer the difference between NPC recovered in base rates and actual NPC incurred for recovery through the EBA, right?
Correct.
And subject to a carrying charge, correct?
Yes.
So again, like the company's original proposed rate mitigation, the amended application is more a matter of the timing of the company's full cost recovery as opposed to cost savings for ratepayers, right?
Correct.
So essentially what the company's amended application did was move the original proposed second step increase back 18 months, assuming the commission grants interim rate recovery through the company's EBA filing with interest, correct?
Correct, but we'd be moving back the actual deferred cost, not just a forecast.
Another component of the company's amended application was to increase the costs associated with excess liability wildfire insurance premiums, right?
I'm sorry, I missed the beginning of the question.
Sure. Another component of the company's amended application, aside from removing the second step NPC increase, was to add costs associated with excess wildfire liability insurance premiums, correct?
Correct. Since we had updated costs based on actuals in, or a better estimate of the actuals in August, we thought it was appropriate to include the actual cost. That way parties had an opportunity to actually address our actual cost in their direct rather than waiting until rebuttal, sir rebuttal.
The company increased its Utah revenue requirement request by approximately $11.5 million associated with those costs, right?
Subject to check, yeah.
Okay. So understanding that the company is not foregoing net power cost recovery by removing the second step rate increase, the company's amended application actually costs customers $11.5 million more than what the company requested in its original application, correct?
It did, and we have since that time actually updated those costs again based on the final policies that were enacted after that.
Let's move to one of your other rate mitigation proposals. One of the four that we looked at in your direct testimony is the company's proposal to not increase Rocky Mountain Power's return on equity, correct?
Right.
The company's current ROE is 9.65%, right?
The current authorized ROE, yes, is 9.65 from the 2020 rate case.
You would agree with me, Ms. Stewart, that if the commission determines that the company's current cost of equity is lower than 9.65%, then holding the company's ROE constant is not rate mitigation, correct?
That is a subject of testimony in this proceeding, yes.
Another proposed rate mitigation in your direct testimony is, quote, a lower equity ratio, end quote, correct? I can point you to that testimony if helpful.
Yeah, let's go back there.
In your direct testimony, page 11, again, the Q&A starting on line 239. You state, in addition to the company's proposal for no increase to ROE and a capital structure with a lower equity ratio. Do you see that?
Right, we dropped the equity ratio to 50/50, which was lower than what was authorized in the last case, and that offsets pretty, to a great extent, the incremental cost associated with debt.
You're ahead of me a little bit, so I want to walk through these components. Current rates assume an equity ratio of 52.5%, right?
Correct.
And the company proposes a hypothetical 50% equity ratio in this case, right?
Correct.
But the company's actual projected 2025 equity ratio for the test period is 44.42%, correct?
I am going to defer that to Ms. Kobia.
Would you accept that subject to check?
Yes.
So when you say lower here, you're referring to a 250 basis point lower equity ratio than what is assumed in the company's current rates, right?
Yes.
But that's 558 basis points higher than what the company's own forecasted equity ratio shows, right?
Yes, and Ms. Kobia explains the basis of requesting a hypothetical 50/50 cap structure.
And so when you call that rate mitigation, really what you're saying is that the company could have proposed a hypothetical capital structure higher than 50%, right?
We could have.
But instead of proposing a higher equity ratio, the company proposed an equity ratio that is only 558 basis points higher than its projected equity ratio, right?
Right, we proposed an overall cost of capital, recognizing all of those pieces go together to try to mitigate the rate impact, and that is in conjunction with holding ROE at the 9.65 rather than increasing it, particularly in light of increasing cost of debt.
All else equal, Ms. Stewart, a higher equity ratio, all else equal, the higher the equity ratio, the higher the weighted average cost of capital, correct?
Yes.
And all else equal, the higher the weighted average cost of capital, the higher the revenue requirement, right?
Say that again.
All else,
yes.
all else equal, the higher the weighted average cost of capital, the higher the revenue requirement, right?
Yes.
Okay. Ms. Stewart, let's move on to the CCA, which I'll refer, let's move on to the Washington Climate Commitment Act, which I'll refer to as the CCA. Can you please turn to your Phase 1 rebuttal testimony? Page 42. Are you there, Ms. Stewart?
I am.
Okay. Starting on line 940 and continuing onto the next page, you set forth the company's interpretation of the 2020 protocol as it applies to the CCA, correct?
Yes.
And we already admitted the 2020 protocol through UAE Cross Exhibit 4, so I'd ask you to pull that up. And if you look on the top of that exhibit, Ms. Stewart, you see a stamp that the company provided as a guide to your exhibit as attached to the testimony that you provided in that docket. If you could go to page 6 as marked there.
I'm sorry, you said that the company provided, you mean that it's a UAE stamp?
No, actually, if you look at the top of this.
Oh, that's our stamp? Okay.
Yeah, that's your stamp, but.
Page
Page 6.
Okay, page 3 of the document itself.
That's right.
Okay.
Do you see starting on line 46 that the protocol states, the proposed allocation of a particular expense or investment to a state under the 2020 protocol is not intended to and will not prejudge the prudence of that cost or the extent to which any particular cost may be reflected in rates. Do you see that?
Yes.
Based on that language, Ms. Stewart, would you agree with me that the 2020 protocol proposes an allocation of costs among the states Pacific Coast serves, including Utah?
Yes,
And the question of recovery of any allocated cost is reserved to the sound discretion of the commission, correct?
right. All states still get to review the prudence of our expenditures and investments and determine whether they were prudent.
In fact, if we turn back to the 2020 protocol, the very next sentence on that page, starting on line 48, reads, "Nothing in the 2020 protocol is intended to abrogate any commission's right or obligation to, 1, determine fair, just, and reasonable rates based upon applicable laws and the record established in the rate proceedings conducted by that commission, and 2, consider the effect of changes in laws, regulations, or circumstances on interjurisdictional allocation policies and procedures when determining fair, just, and reasonable rates." Did I read that correctly?
Yes,
Would you agree with me, Ms. Stewart, that the CCA is a law that did not exist when the 2020 protocol was negotiated or executed, correct?
correct.
And the CCA is a law that did not exist when the commission approved the 2020 protocol, right?
I believe so, correct.
You would agree that the 2020 protocol does not reference the CCA or CCA allowances specifically, correct?
Correct.
You would agree that the 2020 protocol does not reference an emissions allowance regime generally, correct?
Subject to check. I don't recall those words, but I haven't reread the whole thing in quite a while.
Fair. Given that the 2020 protocol reserves for the commission the ability to consider changes in law on interjurisdictional allocation policies and procedures when determining fair, just, and reasonable rates, would you agree with me that the commission has the discretion to determine whether CCA costs fit within the 2020 protocol, and if so, how?
By the way, before the witness answers, I assume the commission recognizes, to the extent any questions call for legal conclusions, that that's not what's expected of the witness. So I'll object to the extent it does, but I'll assume it does not.
The witness is not a lawyer, is that correct?
That is correct.
Okay. All right, we will conclude that it doesn't, objection sustained
Thanks.
with respect to whether it calls for a legal conclusion, but she can give her understanding of the document.
So, and where I'm hesitating is the overall premise that the cost associated with this, the CCA is akin to a portfolio standard. I strongly disagree. It is a tax on the generation that is required in order to dispatch that unit. To operate that unit for the benefit of our entire system, that is addressed in the protocol.
Okay, we can break this down, Ms. Stewart. Yes, please.
Asking the question again to her, I think.
Sure.
Can you ask the question, if you can recall it right there before we read that?
No, I can. I have it written down. There's a long windup, though. Given that the 2020 protocol reserves for the commission the ability to consider changes in law on interjurisdictional allocation policies and procedures when determining fair, just, and reasonable rates, would you agree with me that the commission has the discretion to determine whether the CCA fits into the 2020 protocol, and if so, how?
Yes, I mean, we've seen the commissions make determinations on it, but we continue to state our position that it does address these types of costs, which are a tax and are related to dispatch.
So let's discuss the generation taxes portion. In questioning from Mr. Russell, you discussed the generation portion of generation tax, and I want to focus in on the tax portion. And just so the record's clear, looking at the provisions of the 2020 protocol, your testimony in this case is that CCA costs are system costs and properly allocated to Utah because CCA costs are generation taxes under the 2020 protocol, right?
Right, the allowances associated with operating that plant is a system resource. Those costs should be system allocated.
Because they're generation taxes, correct?
Yes.
Okay. Would you agree with me that the CCA requires Pacificor to acquire carbon emission allowances based on the amount of carbon emissions from the Chehalis power plant, right?
Yes, to the extent of my knowledge about it, yes.
Fair. And the prices of those allowances are set at auction, right?
That is my understanding.
Would you agree with me that the Washington CCA process of requiring the acquisition of allowances is not exactly like a tax?
No. I think there are different ways to levy taxes.
Okay. Mr. Chairman, may I, or may my colleague approach the witness? And to describe these documents, they're transcripts from the Wyoming Public Service Commission proceeding in the company's 2023 rate case. It's very voluminous. We printed a full copy for the witness and her counsel, Michelle. And excerpts for the commission and the court reporter.
Thank you for not giving us.
Ms. Stewart, at the top of this large document, do you recognize the case caption as the case caption associated with the company's 2023 rate case in Wyoming?
Yes.
Do you see under the case caption transcript of hearing proceedings?
Yes.
If you were a witness in the Wyoming 2023 rate case, right?
I was.
In fact, if you go forward 2 pages, there at the bottom, at line 21, you see Joelle Stewart, and you start your testimony at page 153 and continue at least until 237. Do you see that?
Yes.
There was a court reporter at this hearing, correct?
Yes.
You go to the last page, do you see that this document is certified by Eric D. Nordberg, registered professional reporter?
Yes.
And you provided testimony under oath in this proceeding?
Yes.
If you can go to page 207.
I am there.
Starting on line 25, very bottom. Do you see where the question reads, okay, now I'm interested in the phrase you use. You say, quote, akin to a tax, end quote. Would you agree with me that the Washington CCA process of requiring the acquisition of allowances is not exactly like a tax? And your answer is, we have to purchase allowances for all the generation based on a price that is subject to an auction. So correct. Do you see that?
Yes.
Okay. You can set that aside for now, Ms. Stewart. In your testimony, Ms. Stewart, you liken the CCA to the Wyoming wind tax and environmental compliance costs associated with fossil fuel generation, correct?
Yes.
Could you please turn to page 42 of your rebuttal testimony?
I am there.
Starting on line 932, do you see where you state, these direct impacts to generation are consistently system allocated and Utah customers pay these environmental compliance costs and generation taxes incurred by resources that are used to serve Utah customers, just like customers in other states pay costs imposed by Utah on Utah-located facilities. Did I read that correctly?
Yes.
You recognize then that all customers, including those customers in a state that imposes a generation cost, pays the generation cost, right?
Yes.
For example, Wyoming customers pay their allocated share of the Wyoming wind tax, right?
They currently do.
To the best of your knowledge, every generation tax currently in effect, other than the Washington CCA, is charged to all customers of PacifiCorp, not just customers outside of the state where the generation unit exists, correct?
To the best of my knowledge.
Would you agree with me that currently there is no environmental control investment that is in place on one of PacifiCorp's generation units that is not paid for by customers in the state in which the generation unit exists?
Not to my knowledge.
But PacifiCorp's Washington customers don't pay the costs associated with the Washington CCA, right?
They receive free allowances because they're also subject to CETA.
If the commission agreed with you that the CCA is a generation tax, the CCA would be the first generation tax levied on only out-of-state customers under the 2020 protocol, right?
To my knowledge, but it is yes, to my knowledge.
Can you please turn to, again, to your Phase 1 rebuttal testimony, page 44?
I'm there.
Do you see, starting on line 968, you state, and you had this discussion with Mr. Russell.
I'm sorry, which line?
968. Are we on the same page? Okay, great. And do you see where you state section 3.1.2.1 of the 2020 protocol specifically lists examples of state-specific costs that are situs assigned, and those programs include demand response programs, resources acquired to comply with a state's portfolio standards, incentive programs, net metering tariffs, capacity standard programs, solar subscription programs, electric vehicle programs, and acquisition of renewable energy certificates. Did I read that correctly?
Yes.
You recognize, though, that the list you provided here is non-exhaustive, correct?
That is correct. They are examples.
And in fact, in footnote 72 on that page, you include the full provision on state-specific initiatives, which states that state-specific initiatives, quote, include but are not limited to, end quote, those things you list in your testimony, right?
Correct.
77, thank you, Mr. Chairman. Ms. Stewart, you would agree with me that the purpose of the CCA is to incent entities who are subject to it to ramp down emissions over time and to discourage the use of power that emits carbon dioxide, right?
Objection, speculation. Go ahead.
Yes.
Okay.
Oh.
Apparently, we didn't need the.
Sorry.
I was waiting for my big opportunity.
When he said go ahead, I thought he was.
I have prior testimony from you on that point if you'd like to see it. Are we fair? Are we okay with that answer, Mr. Moscone?
I didn't realize I was being questioned, but I know she said yes.
Okay, fair enough. I'll move on. Would you agree with me, Ms. Stewart, that the purposes of the CCA and renewable portfolio standards are the same?
Sorry, would you rephrase the question? Or restate it?
Sure. Ms. Stewart, would you agree with me that the purposes of the CCA and renewable portfolio standards are the same?
Objection, foundation.
Would you like to lay more foundation for
Sure.
that?
Ms. Stewart, what is the purpose of renewable portfolio standards?
The renewable portfolio standard is to meet load within a state based on a certain generation portfolio.
And as the name suggests, it's renewable resources, and so the purpose of renewable portfolio standards is to incent renewable resources and decrease the use of fossil fuel generation, right?
Same objection.
We're going to overrule that objection. Go ahead.
Yes, a renewable portfolio standard requires renewables to serve a portion of the load.
And so, based on that discussion, would you agree with me that the purposes of the CCA and renewable portfolio standards are the same?
Same objection.
Overruled. You can answer the question.
At a high level, both of those laws are addressing Washington's interest in climate change, but they are through different means of doing so. The CETA program is akin to a renewable portfolio standard. It's an emission-based target to lower emissions for serving the load in that state. The CCA is a separate law that is bigger than the utilities. It goes beyond actually serving our load. It's imposed on emitters in the state to address climate change. So while at a high level, they both address climate change, they're two different laws with two different approaches to that subject.
Okay. Ms. Stewart, would you agree with me that the costs above what the company would have otherwise incurred but for a state's renewable portfolio standard are situs assigned under the 2020 protocol, right?
To the extent there are incremental costs with meeting a renewable portfolio standard, yes, those would be situs assigned. We have very limited instances of that being the case where we've actually needed to do that at this point.
Implementing the CCA to accomplish the purposes we've discussed was a policy decision Washington made, right?
It's a policy decision in Washington, but it's not unlike policy decisions in other states to address the facilities with and emissions stemming from their states.
It would be fair to say that Utah may have different policy objectives than those of Washington, right?
Yes.
Ms. Stewart, are you aware that the state of Washington used funds collected through the CCA auctions to provide certain low to moderate income electric customers a one-time bill credit?
I'm not specifically aware of that, but it's also unremarkable to me that the proceeds of a tax would be used to the benefit of the customers in that state.
So you picked up the document I wanted to refer to, and it's what's been admitted as UT LCG Cross 1. Do you see that this is a post from Pacific Power on X, formerly Twitter?
Yes.
Pacific Power is Pacificor's Washington regulated utility, correct?
Yes.
Do you see where Pacificor through Pacific Power's X account states, the Washington State Commerce is launching the Washington Families Clean Energy Credits Program, exclamation point. Funded by the Climate Commitment Act, it offers a one-time $200 credit to low to moderate income electric utility customers. Did I read that correctly?
Electric utility customers, yes.
Ms. Stewart, are you aware that the state of Washington through this program provided approximately 700,000 households with the $200 credit amounting to over $150 million?
No.
Do you have any reason to dispute that?
Objection Foundation has indicated she doesn't have knowledge of this.
Do you want to try to lay any more foundation to that, Mr. Jensen?
Well, I don't think I have to. If she doesn't have knowledge, then she doesn't have any reason to dispute that.
Well, she doesn't have any reason to agree with it either.
Okay, fair enough. I can move on.
But I would like, if you've got the foundation for that, as far as the citation to that or information on that, so we can put it into the record. If you don't have it now, could you provide it at some point in time?
We certainly can.
Thank you.
Mr.
I think it
Chairman.
would be helpful to have that
Yeah,
in
we
the
can
record.
admit it through a different witness.
Okay, thank you.
Ms. Stewart, you're aware that the company challenged the CCA in federal court in Washington, correct?
Yes, I am aware.
As part of that federal court litigation, the company filed a motion for preliminary injunction against enforcement of the CCA, correct?
Yes.
If you can look at what's been pre-marked and admitted as UTLCG Cross 2. Do you have that in front of you, Ms. Stewart?
Yes.
Do you see on the title page, it states Pacificor and Oregon Business Corporation versus Laura Watson in her official capacity as the Director of the Washington State Department of Ecology. Do you see that?
Yes.
On the right side, it says motion for preliminary injunction and memorandum in support, correct?
Yes.
If you go to the last page, do you see that this is dated January 11th of this year and signed by Dallas DeLuca, an attorney for Pacificor, correct?
Yes.
Ms. Stewart, can you travel to page 9 of this document using the court's blue stamp at the top?
I'm there.
Starting on line 12, do you see where the company states, the cost of allowances depends on the state of residence of the customer, resulting in disparate treatment and harm to Pacificor's non-Washington customers as compared to Pacificor's Washington customers. Do you see that?
Yes.
Can you go to page 11?
I'm there.
Starting on line 5, do you see where the company states, the discriminatory allocation of no-cost allowances harms Pacificor's non-Washington customers and Pacificor in an amount that bears direct relation to the amount of Chehalis generation that serves customers outside of Washington. Do you see that?
Yes.
Going down to line 14 on that page, do you see where the company states, the CCA's allocation of no-cost allowances as applied by defendant to Pacificor and its customers violates the Dormant Commerce Clause of the United States Constitution because it impermissibly discriminates against out-of-state customers and businesses, correct?
Yes, that's what it says.
Can you go to page 24, Ms. Stewart?
I'm there.
And I apologize, I switched from the court's blue stamp to the pages on the bottom, so it's actually page 31 of the blue stamp. Do you see where the company, I'm sorry, are you there?
Yeah.
Okay, great. Do you see where the company states, if defendant is not enjoined from enforcing the discriminatory provisions of the CCA and infringing upon Pacificor's,
I don't have a line number, so I don't know where
oh, I'm sorry, line 20.
Okay.
I'll start over. Do you see where the company states, if defendant is not enjoined from enforcing the discriminatory provisions of the CCA and infringing upon Pacificor's and its non-Washington customers' constitutional rights, then they will be irreparably injured. Do you see that?
Objection, before you answer, misstates, the reference is continuing to state that the company states this, the company states that, rather than their attorney. So I'd just like to clarify for the record that a hired attorney made these statements. And I don't know how much longer we intend to go, but this document has been admitted into the record. So to simply have the witness say, yes, that says that, yes, it says that, yes, it says that, is not really providing information of this witness. So I guess I'll just lodge that as an ongoing objection if we continue to do this much longer.
Thank you for the objection. I think the commission finds it useful to have the references to the specific pages. I'm assuming that Pacificor's management reviewed the filing by the lawyer before it was submitted. Do we know that?
I don't know that. I don't know that Ms. Stewart knows that.
Ms. Stewart, do you know whether this was reviewed by you or others in the management? The brief prepared by the lawyer before it was filed?
I know I did review at least a version of it.
Okay, your objection is noted. She can answer the questions Mr. Jensen propounds.
Thank you, Mr. Chairman. That was my last reference to this document, and my question was, did I read that last provision correctly?
Yes.
Okay. When the company references its non-Washington customers in these statements, that includes Utah customers, right?
Yes.
when the company argued these points in federal court in the Western District of Washington, we can presume that the company believed them to be true, correct?
I would assume, yes.
And this is my last line of questioning, we're almost done. Mr. Russell questioned a little bit on this, and I want to clarify for the record. Ms. Stewart, you're aware that commissions in the states of Oregon, Idaho, and Wyoming denied Rocky Mountain Power's request to recover CCA costs from PacifiCorp's customers in those states, right?
Correct.
You would agree with me that the commission in Oregon concluded that CCA costs are properly allocated to Washington under the 2020 protocol, right?
I honestly don't recall this exact findings from the commissions.
Okay. Ms. Stewart, if unlike the commissions in Oregon, Idaho, and Wyoming, this commission allows the company to recover CCA costs from Utah customers, then Utah customers would be the only customers paying these costs arising from Washington state policies, right?
No. California, I believe, has recently allowed them.
So it'd be California and Utah.
Yes.
Okay. No further questions. Thank you, Ms. Stewart.
Okay, is there other cross-examination? Anybody else have any? Mr. Moskin, redirect.
Sure, let's, just a couple of things. Ms. Stewart, I want to direct your attention back to questions, and I'm trying to remember now if it was DPU or who first brought this up, but there was a series of questions going to the free allowances for Washington retail load, and about whether these are based on a forecast, and so I guess my question is, if you have an understanding of whether free allowances for Washington retail load are based on a forecast submitted to the Washington UTC prior to the 4-year compliance period.
I do not have an in-depth knowledge. I know there's a lot of process involved around that, but that's where Mr. Wilding or Mr. Mitchell would be better able to address how we implement compliance with that law.
And as long as we're talking about this topic, do you have there with you the UAE 4, which is the 2020 protocol?
Yes. Oh. Yes.
When you were being questioned about whether the protocol would have this be a situs basis jurisdiction allocation or not, you were directed to a couple of lines, and I want to just very quickly go through that again. If you could turn to page 8, and to make sure I'm looking at the same thing, I'm referring you under 3.1.2.1 interim period state resources. And there's a paragraph there of portfolio standards on 168. Do you recall being asked questions about this paragraph?
Yes.
So there was an implication that this indicates that this should be situs jurisdiction, meaning it only goes to the state where this came from. And recognizing you're not an attorney, but what is your understanding as to why this does not apply, or why this does not preclude the commission from putting CCA costs into the rates in this case?
So regarding the portfolio standard piece of it, I mean, the CCA is separate from the portfolio standard, which is implemented under the CETA law. So we don't believe it applies to the portfolio standard. It doesn't, the costs associated are not directly related to surveying load in that state. As for the state-specific initiatives, particularly the examples that are given there, those are all also related to serving the load in that state. Those are programs for customers in that state. Or in the case of acquisition of RECs, that's also related to, typically to a program associated with the customer load in that state. So in some instances, we have to acquire RECs to support the portfolio standards. The acquisition of those RECs would be allocated to the state requiring the use of them for compliance with a law. But they are customer-based for the load of serving, for serving the load of customers in those states, or programs related to customers in those states, as opposed to the CCA, which is a much bigger law associated with, more than just electric utilities, but with triggering the facility, our facility in the state.
Thank you. Would you turn to page 10 in this same document? And look at line 217. Is it the company's understanding or position that what the state of Washington is required as pertains to Chehalis, a generation-related dispatch cost?
Yes.
If you were to flip over the very next page, looking at line 32, and again, this is all under the miscellaneous costs and taxes provision. And
Was that line 232?
232, thank you. There's another bullet point of a type of expense that will be allocated using the SG factor. Will you, in fact, just read for us the bullet point on line 232?
Generation and fuel-related taxes will be allocated using the SG factor.
And very simply, what's the SG factor?
System generation.
Okay. And is it the company's understanding or position then that the CCAs that are at issue here are a type of generation-related tax?
The allowances, yes.
Chehalis, which customers does that plant serve?
All customers across all 6 states.
And does the company have the ability or the choice to forego paying this this cost or this tax that's in the state of Washington?
Not without shutting down that Chehalis plant. And shutting down that plant would actually increase cost to all customers across all of our states.
So very simply stated, is the Washington CCA cost a cost that is necessary for the company to incur in order to serve Utah customers?
Yes.
Thank you. No further questions.
All right, is there any recross?
Yes, very briefly. Ms. Stewart, in your responses to questions about the Washington CCA, you've sought to identify a distinction between the way that the CCA works from the way that CETA works, right? But you should probably in your mind.
Yes.
Okay. But you acknowledge also that the costs to Washington ratepayers associated with CETA compliance is the acknowledgement that those customers have to comply with CETA and that there are costs on them is the reason that Washington allows its state ratepayers the free allowances under the CCA, right?
That is my understanding, yes.
Okay. So in that sense, then, those two laws work together. for purposes of determining the cost of the allowances under CCA, right?
Well, I believe there is a reference to the other law in this law, or at least in the regulations to implement the law. I don't know that that appears in the law itself. But I don't think it's unremarkable a law could point to another law or regulations.
Okay, fair enough. Thank you.
That's all?
Yes, that's all from UAE. Thank you.
All right, is there anyone else who has recross? Okay, the witness can step down and be excused. Oh, wait, no, I'm sorry.
I'm not giving up my chance.
We'll hear first from Mr. Harvey, who has some questions. Commissioner Harvey.
Hello.
Hi.
Excuse me. I'd first like to address some of your questions about, or not your questions, your statements about whether or not the EBA costs, or the net power costs, sorry, are out of the company's control. And just to be, for my clarity's sake, the argument that at a fundamental level, Pacificor says is justifying the increased EBA, the increased net power costs being collected through the EBA on a going forward basis, is that the company had no control over these factors. Is that correct?
Correct. I mean, the net power costs are largely driven by the commodity costs of fueling our plants or acquiring market purchases.
Okay. Would you agree or disagree that in the long term, the company's investment decisions in generation resources determine the percentage of their total energy needs that have to be purchased from the market versus self-generated?
Over the long term, yes. On a short-term basis, based on volatility of loads and availability of resources, as well as market prices, all of that goes into, is taken into account in that real-time basis as we are operating the system. But looking at the resource procurement over a longer period, yes.
Has the percentage of the total, the percentage of the purchases that are being made versus the self-generation, how has that changed over, say, the last decade?
I will actually defer to Mr. Mitchell. He addresses that in his testimony.
Okay, that's fine. You mentioned in, I believe it was your opening statement, $7 billion of new capital. Is that correct?
Yes, through the end of the test period.
Through the end of the test period.
Since the last rate case, I believe.
Oh, okay, thank you. Appreciate that clarification. That's good. Do you know, and this may be deferred as well, but do you know if that was planned to be primarily purchased through equity or debt?
I would defer to Ms. Kobia for financing of capital investments.
Okay. Okay, and then with respect to the mitigation measures that were extensively discussed earlier, if we take the hypothetical that Pacificor's forecasted net power cost is both correct and prudent, so starting with that as the hypothetical, if I'm looking out at how rates would be collected over time over several years, the mitigation proposal would be to say in this initial time period, costs would be deferred and the rates collected would be lower. Is that correct?
In the initial,
rate effective period.
In the rate effective period, yes. If we put the full forecast into rates,
well, no,
or our mitigation proposal.
Your mitigation proposal.
Yes.
Sorry, I just want to clear there. But the premise of the question the series of questions is that Pacificor's forecast is correct and that it would be prudent.
Okay.
But it is Pacificor's proposal that I'm talking about, not in rates.
Okay.
So then so we have that initial lower cost with the actual costs. Let me be precise. We have the initial lower rates with the actual costs, some portion of them being deferred. In that next period, when those deferred costs are now put into rates, the amount in base rates is still there, correct? So rates go up at that point, but is that correct?
I guess at what point, so base rates go up in this case?
Well, not base rates. There would be an EBA surcharge put on top of base rates in that second
Right,
period.
our deferral for that second period, but it wouldn't necessarily cause rates to go up because the deferral after, so 2025, if the commission approves our proposal to put in only a portion of those base power costs, and then actuals occur for 2025. In 2026, we'd be filing for collection of that deferral, which is, let's say, the 258, I think was the number. That deferral is actually less than the deferral that would be in rates for 2024, because right now 2024 is looking pretty close to 2023 of what's in rates. And so the deferral amount is less. And so what the customers would see in the EBA is a rate decrease because the amount in rates for the deferral is less.
But the base is still there.
The base goes in with the rate case, yes, and so customers would see the increase of the base in the rate case, but then it's still a decrease once you get to the deferral period because you're comparing the deferral to what is in the EBA for deferral recovery from the prior year. So right now we have about 431 million in deferred power costs going through the EBA. Let's say the deferral next year for 2024, which is, outside of this case, that would just go through the normal process. That deferral is, looking to be about the same amount. So the rate change for the EBA next year would be de minimis, hopefully. And I don't have the specifics of what the forecast is, but in this scenario, if it stays still at 431, the EBA on July 1 would be essentially zero because that amount is already being collected in rates. And then for 2025, as we start deferring it, because we've increased that base of a portion of the way up, the deferral should be significantly less. And so then in 2026, we're dropping rates because we're collecting a smaller deferral than the prior year.
Thank you, I appreciate that. To clarify then, Pacificor's long-term, or at least 2 or 3 year term forecast is for net power costs to be less in 25, 26 than they experienced in 23, 24.
I don't have the forecast for those years. Right now, Mr. Mitchell would maybe be able to better address the forecast. We've certainly been wrong on our forecast the last few years, so we know it won't be precise, but he can speak more to what is in the forward price curves.
Okay. And then in terms of the carrying charge on that account, where a substantial amount is being deferred, not because a forecast was missed, but simply by a policy choice to do mitigation, would the company be willing to share that carrying charge with the customers in any manner?
Well, there is a cost to us of funding the cash, and so it is the financing cost of funding that. So there is a real cost to us, and so I think Ms. Kobia could speak to, the cost of us financing that cash versus what that carrying charge is, which is the customer deposit rate.
Okay, thank you. In terms of the ICA, that's being proposed. I just want to understand an answer that you gave earlier with respect to the idea of self-insurance. Is my understanding of this correct? I'll say what my understanding. Pacificor is saying that if they begin to do the self-insurance that Utah law contemplates, that if it's in a balancing account, that then there's no excess cost that might be over-collected during that transition process.
As you build a reserve, we would build a reserve for self-insurance over a number of years, is what we've sort of contemplated in order to mitigate near-term rate pressures. And then once you have that reserve built, if you've not been making claims from it, then you would adjust that surcharge so that you're not overfunding that reserve.
Okay. And then for the excess liability insurance, how often are those policies renegotiated, or what's the term of those policies?
So typically, those policies are 12-month terms. For this last round of policies that we entered into August, September timeframe, they were, I want to say, 18-month policies. So the current policies will cover us for a longer period until February of 2026. And we did that. Ms. Coleman in Phase 3 can address that in much more detail. But, I mean, high level, we have a longer-term policy to try to get policy renewables out of that time period of the fire season, essentially, and to give us a little bit more stability for a period of time as we work through the potential move to self-insurance.
Okay, thank you. So I want to move to the Washington Cap and Trade Program. The motion for preliminary injunction that was referenced earlier, would you characterize Pacificor's efforts in that lawsuit as being trying to protect other customers from those, what the lawsuit characterized as those unconstitutional costs?
Yeah, I mean, trying to protect other customers, but also trying to get recovery of our costs. We're being financially harmed for complying with a state law. And so it's part of our avenues of addressing. I know there was a lot of interest from our states for us to take that on, and it was denied by that court.
So turning to those costs, as was mentioned, Oregon, Wyoming, and Idaho have denied the request for recovery within their states. What's happened to that portion of the costs?
Well, those costs are currently not in rates in those states, and we are appealing those decisions in all three of those states.
Okay. So in testimony in this case, you've brought up the concept that if Utah were not willing to pay for those costs, they shouldn't receive the benefits of that generation. Is that correct?
Correct.
Has Pacificor applied, or does Pacificor plan to apply that same policy to the states that have already rejected those costs?
We have made the same assertions in those states as well, but the one I recall most recently was Idaho. They also rejected our proposal to remove the entire Chehalis plant out of rates. And so the states have retained the plant within their states. They have not removed it. They've just removed the CCA cost, even though we did raise that as well in those states.
So even though Pacificor has raised that, they don't have any way to implement that for those states?
Not absent, another filing to reassign that plant reallocate that plant, the cost and benefits of that plant.
Right, because it is Pacificor's testimony that even with what Pacificor terms the tax, it's still a lower cost effect on the overall system cost.
Correct.
Does Pacificor have any plans to make filings to ask that that be removed from those states, i.e. move it to states that are willing to pay for it?
Well, so our current 2020 protocol expires at the end of 2025. We anticipate making filings in our states next year for a new allocation protocol, and I would fully expect we would address that plant in particular at that time.
And then just a last question on the protocol itself, the interjurisdictional, what's the exact name, sorry, interjurisdictional allocation protocol. That is arrived at through what was termed the MSP, or the multi-state process?
Yes.
Right. Would it be fair to summarize the thought process behind that as saying that the states and Pacificor
0.2 million is what I heard in your rebuttal testimony following the adjustments. It was 331.5. What's the difference in the, what is 1.3 million dollars? Do you know?
Yeah, there was an adjustment in our SIR rebuttal testimony that was in Ms. McCoy's testimony, and it was related to an adjustment for tax. So it was in our SIR rebuttal testimony after rebuttal that we identified an additional
1.3.
adjustment. Yeah.
Okay.
1.3 or 1.2, but yeah.
Yeah. Okay. In discussing the CCA provisions in Washington, under Washington law, you indicated that Oregon, Idaho, and Wyoming have all denied allocation of that pursuant to the 2020 protocol, and that California has allowed that. Could you give me an estimate of what the dollar amount that California will pay, given their small percent under the allocation formulas?
No, they are about 2% of our system, but if I could think of what the full CCA cost was, I could do 2%, but
2% of the total cost that you would seek to be allocated?
yeah, I believe roughly, yeah.
Okay, all right. I have a couple of questions from your testimony that really hasn't come up much in your. Is that better? With respect to your insurance coverage, you indicated, I think in your testimony, that you renew insurance coverage in about August of each year.
It has traditionally been in August, and now we're moving to February timeframe.
And you testified on page 24 of your testimony that the costs for commercial excess liability insurance for the 2023-2024 policy year were up about 270%. Do you know what percentage increase you incurred in the 24-25 policy renewal that you just finished in August of this year?
Well, subject to check, Ms. McCoy will have those numbers since they're in revenue requirement. So in 2023, it was about 122 million, you see there. In 2024, it was I think our final number landed around 183 million total company.
Well, that's for an 18-month policy rather than.
That's on an annualized basis, so that would be for the 12 months.
Okay, all right, okay, thank you. Just one question. You spent a lot of time in your testimony talking about, and your pre-file testimony and today about the efforts to be transparent in talking about the amendments to your petition. Are you aware that comments were expressed by political leaders after you filed your amendment, expressing gratitude that Rocky Mountain Power had decreased the amount of their rate increase? Do you recall, for example, the Speaker of the House making comments of that and were widely reported in the newspaper, and other political leaders?
I don't personally recall gratitude,
Well, gratitude
for anything in this case.
Gratitude may, let me rephrase it. Gratitude may be a little too, but acknowledging and stating that there had been a decrease in the amount of rates that Rocky Mountain Power was seeking. You recall that?
I actually don't. I was very busy at that time too, so I don't always follow our news clips.
Let me ask this then. Did you have any discussions clarifying with legislative or government leaders the nature of the change in your rate proposal with the filing of the amended application?
I did not. I appeared recently at one legislative hearing and clarified that those costs would be recovered through the EBA when asked.
In fact,
But-
it was the last question asked you, and you did clarify that.
Yeah, but I also don't regularly, if hardly ever, speak to legislators. And I don't want to give you a runaround, but Mr. Garish would actually be the one to ask about that.
Well, I guess I'm just wondering whether you had some impression that that the public, as perhaps expressed through leaders in the state, thought that Rocky Mountain Power was seeking a smaller increase in rates.
No, I don't have that personal knowledge. I'm very aware of statements made by politicians and public comments in the newspaper articles prior to our amendment.
Right.
But post our amendment, specific references to things legislators may have said, I have 4 rate cases going, and I probably wasn't paying attention.
I understand. That's fine. I just was curious as to whether that was something that was within the scope of your knowledge and understanding. We may have others who know that. With respect to the Utah Fire Fund that was authorized by the Utah legislature in the 2024 session, it allows up to a $3.70 surcharge to be applied to residential customers to fund that Utah Fire Fund. I want to ask you, when do you plan on implementing that? Is that a decision that you've made as a company?
I have not made that specific decision at this point. We've just had way too much going on. I had hoped to try to work with some of the parties in Utah prior to making that filing as well. And so it wouldn't be until next year that we would, well, obviously at this point, since it's mid-December, but I've got 2 other cases still going before I can turn more attention to that.
With your adjustments that you've made in your request, what is the projected average increase in a residential customer's bill, percentage-wise?
I don't know. I don't think we've run it through, since they're in different, revenue requirement is in a different phase from our, obviously phase 2 is pricing and cost of service. We did not run it through the cost of service to come up with that on a specific class basis. So I don't know that off the top of my head.
Okay. Well, that obviates the need for me asking a few other questions on that. I have no other questions. The witness will be excused. Thank you, Ms. Stewart, for your testimony today. We will take a 1-hour lunch break and reconvene at 1:15. this afternoon. Just as one matter, I had a brief discussion with Mr. Jensen as we broke for lunch about the documents he used for impeachment purposes. He did not introduce those as exhibits, but just so we all are clear, I asked him to provide to the commission, and it will be in the record. We already have a copy of the excerpts from the transcript, and we now have a copy of the entire transcript from the proceeding in Wyoming. Is there any objection to those being received? Okay. We'll consider them as part of the record. They're not marked as exhibits. I think we could take judicial notice of the fact that they're public proceedings and these are official transcripts, so we're fine. Okay, is there any other matters to discuss before we have Rocky Mountain Power call its next witness? Okay, just.
The DPU's not here yet.
I don't like beginning without council present, so we'll just take a second. Mr. Moore, do you have any way to reach her, find out where she's?
I could give it a shot.
Why don't you try to do that? We want to know if she's, hopefully she's, okay. That was a flourish. We just had stated we wouldn't begin without you, so we're glad that you arrived almost exactly after I said those words.
Thank you for your indulgence.
Okay, Mr. Saban, we can call your next witness.
Yes, thank you, Mr. Chairman. Rocky Mountain Power calls Nikki Kobia to the stand.
Ms. Kobia, would you raise your right arm to the square, please? Do you solemnly swear that the testimony you're about to give in this matter pending before the Public Service Commission of the State of Utah will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can be seated. Turn to Mr. Saban for direct.
Good afternoon. Could you please state for the record your full name and title with the company?
Yeah, Nikki Kobia, and I'm the Chief Financial Officer for Pacific Corp.
And did you, Ms. Kobia, cause to be filed in this proceeding both pre-filed direct testimony and pre-filed rebuttal testimony?
Yes, I did.
And do you have any corrections to that testimony?
I do have one number that needs to be corrected on both the direct and the rebuttal testimony.
Okay, why don't you please identify the page and the line number that needs to be corrected?
So in my direct testimony on page 10, line 198, there is a number that says 53.41, and that needs to be 52.5.
Could you give us the context of what the number refers to?
Sure. So the number is referring to the average equity level for operating companies that's referenced in Ms. Bulkley's exhibits.
Okay.
And that we had just picked up the wrong number, and that same number shows up again in rebuttal. So on page 2 of my rebuttal testimony, that same 53.41 is there, and it needs to be 52.5.
Thank you.
Thank you. With that correction, are there any other corrections that need to be made to your testimony?
Nope, no other corrections.
Okay. And if I was to ask you the same questions that were provided in that both your direct and your rebuttal testimony, would you provide the same answers that you've provided in your pre-filed testimony?
Yes, I would.
Okay. Mr. Chair, I move to admit into the record Ms. Koblia's pre-filed direct and pre-filed rebuttal testimonies.
Okay, is there any objection to that from any of the council that are present? Okay, it will be received into the record.
All right, thank you. Ms. Kobia, have you prepared a summary of your direct and rebuttal testimonies for the commission and the other parties?
Yes, I have.
Would you please share that with those in the hearing today?
Yes. So thank you. Good afternoon, commissioners. As we said, my name is Nikki Kobia, and I'm the Chief Financial Officer of Pacific Corp. Pleased to be here today to provide a summary of my direct and rebuttal testimonies. My direct testimony supports Rocky Mountain Power's overall cost of capital recommendation, including the proposed capital structure and cost of debt, Specifically, my testimony advocates for a hypothetical capital structure with a common equity level of 50%, which is lower than the company's currently authorized equity level of 52.5%. The company also proposed a cost of debt of 5.25%, which was updated in my rebuttal testimony to 5.21. Sorry, hope I said 5.25, updated to 5.21. The proposed hypothetical capital structure is intended as a form of regulatory support to preserve the company's creditworthiness and maintain certain credit metrics examined by credit rating agencies. Since the last rate case, the company's financial results have not met rating agency expectations, and the company's credit rating have been downgraded, and its actual capital structure has become more leveraged due to increased costs associated with ongoing operations, significant capital expenditures to reliably serve load, and wildfire liabilities, which is an industry-wide issue that the company is seeking to proactively address. My testimony further explains how these circumstances increase the risk of future additional credit downgrades, which could adversely affect the company's access to capital markets for ongoing operations and capital investments, and cause further expenses and rate increases due to higher borrowing costs. Indeed, the company has already seen traditional debt investors opt not to participate in our latest bond offering due to the recent credit downgrade. Maintaining or improving our credit rating enables the company to attract capital from a broader group of lenders and avoid costly collateral requirements. This includes ensuring access to short-term liquidity needed for unexpected events such as extreme weather. Customers benefit from this through a lower cost of capital, as the company can secure loans at more competitive rates. Reviewing PacifiCorp's history demonstrates that a financially strong company provides positive financial benefits for customers in the form of access to capital on reasonable terms. I also note that the equity percentage in the company's proposed cost of capital is very reasonable. In fact, the proposed 50% equity is below average when compared to equity ratios of the proxy group of companies relied upon in company witness Bulkley's testimony for determination of return on equity. In addition to proposing a hypothetical capital structure, the company is also taking further measures to shore up its financial condition. Our parent company has suspended dividend payments until the end of 2028 to allow the company to retain earnings from ongoing operations instead of these funds being paid out to shareholders. This will in part help the company to fund necessary investments. The company has also adjusted its capital expenditure plan by delaying or eliminating certain investments and is prioritizing efforts to reduce wildfire risks through wildfire mitigation efforts. These steps reflect the company's commitment to actively managing its risk profile, maintaining key financial metrics, and preserving its credit rating, ensuring continued access to capital markets, and keeping borrowing costs low. Doing nothing or assuming liquidity will always exist regardless of the credit rating is not good business management, nor will it lead to financial stability. The company is currently working with credit rating agencies and believe that combined with the proposed capital structure, these measures will position the company to demonstrate financial stability and avoid a further downgrade. I strongly oppose the capital structures proposed by intervener witnesses in this case, as they ignore the very real concerns that such structures would present for both the company internally and externally, and would, in my view, cause further financial instability at a time when just the opposite is needed. In my rebuttal testimony, I address the various arguments presented by parties opposing the company's proposed capital structure and cost of debt. Specifically, I rebut the testimony from the OCS, which asserts that it is appropriate to consider the common equity ratio of parent companies and short-term debt when evaluating a utility capital structure. I address the DPU's claims regarding the precedent for hypothetical capital structures and suggestions that past rates ordered by the Commission were too high and were unjust or unreasonable. I respond to WRA's testimony concerning the reasons for the cancellation of the 2022 all-source RFP and its assertion that the proposed capital structure primarily benefits shareholders. Lastly, I rebut the UTLCG's testimony that a utility's capital structure should align with those of other competitive industries and its similar premise that the proposed capital structure will primarily benefit shareholders. With regard to the cost of debt, my rebuttal testimony updates the cost of debt and reduces it to 5.21%. I also addressed the DPU's proposal to lower the rate to 5.17% by replacing the forecast cost of the company's 2025 debt issuance with the assumption of first mortgage bond issuance rather than junior subordinated notes. After reviewing intervener testimony, my position remains that the capital structure proposed by the company is necessary for it to stabilize its financial condition and avoid a further downgrade. The proposed cost of debt should be 5.21%, and a 50% equity structure should be adopted as a hypothetical measure to maintain the company's investment grade rating and ensure continued access to debt capital markets at a reasonable cost. I've been with Pacific Corp for 27 years, and these are unprecedented times for the company, making the kind of support the company is seeking critical to preserving financial integrity at a time when substantial capital investment is necessary to meet ongoing operational requirements and policy objectives. Thank you for your attention to our pre-filed materials and the testimony that will be presented in the next 2 weeks and in future phases of this proceeding. And that concludes my summary.
Thank you, Ms. Kobia. Thank you. Back to you, Mr. Saban.
Yes, thank you. Ms. Kobia is available for cross-examination.
Okay, we now have this established as a traditional order. We'll go to Ms. Schmidt.
I'm in trouble then. I streamlined a couple of my cross-examination exhibits, and I don't have them here yet.
Okay.
May I please be allowed to go later in the order? Ms. Kobia?
You're asking us to break with a long-established tradition.
Exactly. Please.
We'll do so. We'll go to Mr. Moore.
Thank you.
Hello, Ms. Kobia. I just have a short set of questions. Excuse me. Hello, Ms. Kobia. I'd like to begin with asking you some questions concerning our Rocky Mountain Power's proposed capital structure. Can I have you turn to page 2 of your rebuttal testimony and read to yourself the question and answer beginning on line 19 of page 2 and going through line 44 of page 3?
Of my rebuttal testimony?
Yes.
Page 2 starts with line 21. Or do I have a bad copy?
Let me double check that.
Are you referring to the rebuttal or the direct?
I believe I'm referring to the rebuttal.
Okay.
And you're...
I'm asking her to read to herself the question and answer starting on line 29.
Okay, thank you.
There we go.
All right.
I apologize for my mistake.
Okay, no problem. All right, yes, this is about the holding companies.
The question the question and answer you just read deals with the dispute between the OCS and Rocky Mountain Power regarding whether they use the proxy group's operating companies or the proxy group's holding companies for the purpose of comparison to determine the appropriate hypothetical capital structure for RMP. Isn't that true?
Yes, this is the conversation about holding companies versus operating companies.
Specifically, you propose the use of proxy group's operating companies, and the OCS proposes the use of proxy group's holding companies for the comparison. Is that correct?
Yes, that is correct.
Now may I direct you to page, let's see if I did a better job at this. Page 2, line 35, 38 of your rebuttal testimony, and I'm going to read you a sentence of your testimony. Just because holding companies are using proxy groups to determine the cost of equity, as these are based on the entities that have public equity, does not mean they are relevant comparisons for a capital structure. Did I read that correctly?
Yes, that's correct.
Consistent with what I've just read, isn't it true that only the holding companies have public data that is needed as inputs in the ROE models? Therefore, the holding companies must be used for the ROE calculations, and it is not possible to use the ROE model using the operating companies.
So that when we talk about the return on equity, that's a better question for Ms. Bulkley. And so what I've referenced here is that she has data associated with the operating companies, which are comparable to Pacific Corp, and that is the relevant comparison for the capital structure component. But yes, the ROE piece, you need to talk to Ms. Bulkley about.
You don't know whether well, didn't you just testify? Just because the holding companies are used in the proxy groups to determine the cost of equity, as these are based on the entities that have public equity, does not mean that they are relevant to the comparison for capital structure. Just because holding companies, you say, are used in the proxy courts to determine cost of equity, because these are based on entities that have public equity. Okay. Let me start. Just because the holding companies are used in the proxy groups to determine the cost of equity, therefore you know that the holding companies are used in the ROE models. Isn't that true?
That's what I said, yes, that Ms. Bulkley has used the holding companies associated with the ROE. And then my comparison here is at the operating company level, we have the data associated with those operating companies that compared to Pacific Corp to come up with what a reasonable capital structure would be for a comparable company.
Yes, but it's impossible to use the operating companies for the ROE because the operating companies do not have public data market information.
And I say I'm not using it for the return on equity, that Ms. Bulkley uses that data for the return on equity. Mine is on the capital structure, and the capital structure comparison is at the operating level.
I understand. I haven't gotten to the point yet where we discuss which one's proper.
Okay.
The point I'm just trying to make, and I think, or when I put these questions together, I thought you had testified to this, that the ROE models use public equity data. That's what you said in your testimony. Isn't that correct?
So if we read the statement again, I said, yeah, just because those companies are at the holding company level for the ROE model doesn't mean it's applicable to the capital structure and relevant for this conversation. And Ms. Bulkley would better be able to answer the use of those holding companies for the return on equity component.
Well, you don't know, what do you mean when you said at line 35 to 38, within the parens, as these are based on entities that have public equity? Why is that relevant to your statement?
I was just clarifying that when we talk about the cost of equity, then again, Ms. Bulkley is using that data for the return on equity component. But as I go on further to say that it's not relevant for the capital structure comparison.
All right, I understand. My point just was that the holding companies have the public information that is needed for the ROE models. And you agree with that. I believe that's what your testimony says.
Yes, that's what it says, and Ms. Bulkley will be able to address that.
I don't want you to go through those models.
Good. I don't want to either.
Now, I'd like you to turn to page 10 of your direct testimony, lines 186 to 193.
I'm there.
And I'm going to ask you to read into the record the question starting on line 186 to the end of the first paragraph of the answer.
So sorry to interrupt, I just want to be careful. These are confidential. There's some confidential information on this page. And
Okay.
Look at the lines and see if that contains confidential information. Maybe Mr. Moore, will you tell us? We'll have to do something if we have
so, Mr. Moore, what is it you're focusing on there?
I am looking only on lines 186 to 193.
Okay, the information in the chart is confidential, so as long as you're not going to be verging into that information in your questioning, I think we're okay.
I don't believe I am. Let me double check. Thank you, Mr. Cameron.
Stephen, if we start to venture into confidential information, we'll take action to preserve it.
Thank you.
Mr. Moore, just be cautious. And if you
I don't believe I am. The confidential information is on the chart at the top of the page. Isn't that correct, Ms. Kobia?
Yes.
I want you to go down to line 186.
I'm there.
And I want you to read into the record, if you would, the question and answer ending in 193 with the words a hypothetical capital structure.
Sure. Has the commission ever approved a hypothetical capital structure for the company in a prior rate case? Yes. In docket number 99-035-10, the company proposed a hypothetical capital that was derived from the average capitalization of comparable electric utilities used to develop its return on equity recommendation. The Division of Public Utilities agreed with the company's proposal, and it was approved by the commission, finding that the company's sample of comparable firms is a reasonable basis upon which to determine a hypothetical capital structure.
Now, Mrs. Kobia, I'm going to have OCS Cross Exhibit 1, a copy of the first 2 pages of the order in docket 99-03510 that you just quoted from. And I'm going to direct your attention to page 2 of the order. And after I get you this order, I'm going to read the first 2 sentences under that heading, under the heading capital structure. I apologize, I didn't have all my exhibits pre-filed.
That's fine, we'll take care of it as we go along. Or you've distributed OCS
Cross Exhibit 1.
You've distributed OCS Cross Exhibit 1. Everybody's had a chance to look at that. Is there any, I'm assuming you're going to...
I'm going to read 2 sentences from it.
Okay, well, we'll go ahead and see if anybody has objection to it being admitted. Yeah. Any objections to OCS Cross Exhibit 1 being admitted? I'm looking at Mr. Saban and Mr.
Mr.
Kumar.
Saban, I have a complete copy of the case if you're interested.
Well, my only thought was I just don't, because I don't know yet what you're going to ask. I don't know whether having the entirety of the order will be necessary. Could I reserve the right to ask for the entirety of the exhibit to be put in if necessary later?
Yes, you can reserve that, but we'll go forward conditionally receiving this until we hear if we need the full document. This is just an excerpt of the order. You may proceed, Mr. Moore.
And those 2 first sentences under the heading capital structures provide, the company recommends a hypothetical capital structure of 47.4% long-term debt, 3.85% preferred stock, and 48.8% common equity. This was derived from the average capitalizations of the comparable electric utilities used to develop the company's return of equity recommendations. Did I read that correctly?
Yes.
The passage I just read states that the company used in the comparison to determine the capital structure in docket 99-035-10 are the same companies used to, quote, develop the company's return on equity recommendations. Isn't that true?
Yes.
Therefore, because only the holding companies have the data necessary to run the ROE models, in docket 99-035-10, the company used and the commission approved the use of holding companies for the proxy group comparison. Would you agree with me on that?
Objection misstates the document and lacks foundation. That's not what the document says.
Would you like to rephrase the question or lay more foundation, Mr. Moore?
Well, I believe the quote, as I just read, is foundation for my paraphrasing of the quote. The quote states that that the company's hypothetical capital structure was derived from the average capitalization of comparable utilities used to develop the company's return on equity recommendations. We have established, I think, that only the holding companies can be used for the ROE models. Therefore, that is foundation for my conclusion that in docket 99-03510, the company used and the commission approved the use of holding companies for the proxy group comparison to determine hypothetical capital structure.
Mr. Saban, you have any further response?
I have no idea what entities were used in 1999 to calculate the ROE or capital structure, but the document itself does not say what entities were used, and in fact, it says it used only the ratios for the utility companies, not the holding companies, and Mr. Moore just acknowledged that, so I just don't think we can assume, as he does, what the entities are that were in play back in 1999, because I don't think we know.
Okay, your objection is noted. I think that explanation is on the record. I'm going to allow Mr. Moore to continue with his line of questioning. You can ask, you can reserve that objection. You can object again if you think he ventures farther afield. Mr. Moore, you can continue. The objection's overruled.
Now I'm going to hand you, Mrs. Kobia, OCS cross exhibits 2 and 3.
Did you withdraw the question? I mean,
No,
we didn't get...
I don't believe I had to withdraw the question if I misunderstood you.
No, but I thought you had a question pending when the objection was
Right.
raised, and you didn't get an answer to the.
You're right. I anticipated having pushback from Ms. Kobia rather than Mr. Saban.
Well, you still may. You still may. But you had a question pending, and I just want to make sure we're clear on the record here.
Thank you, Chairman. I'm going to read my question one more time, and then you can push back.
Thank you.
Therefore, because only the holding companies have the data necessary to run the ROE models, in docket 99-035-10, the company used and the commission approved the use of holding companies for the proxy group comparison. Isn't that true?
Back in 1999, that was the situation, and if you look at my rebuttal testimony, I make reference to why I was pointing out the precedents was to provide various examples of situations where commissions have approved a hypothetical capital structure. It's going to be different in each and every case, and so concluding that exactly what happened in 1999 is applicable, 20 some odd years later, to me is, it's great data, but the exact nature is and will be different, and in this case, we have access to operating company data.
I'm going to object to this answer. Whether a commission president is binding on this commission is a legal question, and she's not a lawyer.
Mr. Saban, you want to respond to that?
Well, he wanted an answer, and she gave him an answer, and I don't think he likes the answer, so he's trying to cut her off. I don't think she's trying to give a legal conclusion. I understood her to be saying why she provided it as an example of precedent, not that it was binding on this commission.
Well, Mr. Moore, you're asking a question on cross. You can control the order of your questions. You can have the witness respond without a narrative answer, but the answer's been given. It'll remain in the record. You can ask follow-up questions and further attempt to draw out what you need on cross. Go ahead.
Thank you. Now, the portion of your testimony that you quoted from, where you said that In docket 1999-03510, the company proposed a hypothetical capital structure that would derive from the average capitalization of comparable electric utilities used to develop its return on equity recommendations. The Division of Public Utilities agreed with the company's proposal, and it was approved by the Commission, finding that the company's sample of comparable firms is a reasonable basis upon which to determine a hypothetical capital structure. You remember that testimony?
Yes.
Okay. I'm going to have handed to you OCS Cross Exhibits 2 and 3. These exhibits have been provided to the parties pursuant to the scheduling order. However, I'm going to provide the commission, the court reporter, the witness, Mr. Saban, the hard copies, and I have hard copies to provide anybody else who would like to look at them.
And I'm assuming this,
I think Mr. Vasek has the wrong, is that, oh, no.
OCS Cross Exhibit 2 is the direct testimony of William E. Parasini in docket 99035-10.
That's correct.
I'm assuming that this doesn't contain confidential information. You said you would distribute it to anybody else who wanted a copy,
I see nothing in it that's confidential. I retrieved this from the archives. This is a 20-year-old case.
Okay, all right. Any objection to this being received?
I don't think so from our perspective.
Okay. You're moving for its admission?
I wanted to state what it was before I
Please do
moved to
that,
the commission.
please.
This is the written testimony of the companies, in this case, Rocky Mountain Power was going through a merger, so there's references to Pacificor and UPNL. I just refer to it as the company. Is a written testimony of the company's capital structure witness, Mr. Parasini, and Exhibit 3 is the company's return on equity of witness, Mr. Hadaway. Mr. Hadaway is the return on equity witness of the company. These documents have been previously provided to your counsel pursuant to the scheduling order. Have you seen these documents before?
Yes.
Okay. Now, may I direct your attention to...
If you want it to be admitted?
Thank you. Yes, please. I would move for them to be admitted. I had them on admission on a different part of my sheet.
Sure, no problem. We've already asked for any objections after Mr. Moore's explanation. I assume there's still no objection. Okay, this will be received. Thank you. OCS Cross Exhibit 2.
May I direct your attention to OCS Cross Exhibit 2, which is a written testimony of Mr. Persini. On page 1, line 21 to 23, he states the purpose of his testimony is to provide the company's capital structure proposal. Isn't that true?
Yes.
Well, just a correction. She didn't state it. Mr. Parasini stated. I think you said she stated, and to be clear for the record, I'm sorry to interrupt you, but
that's fine. I'm a little dyslexic. I will be making small changes like this from time to time. I ask the commission, the parties, to please bear with me.
We'll do so. Thank you.
I'm going to state that question again. May I direct your attention to OCS Exhibit Number 2, which is the written testimony of Mr. Paracelli on page 1, lines 21 to 23. He states the purpose of his testimony is to provide the company's capital structure proposal. Isn't that true?
Yes, that's what Mr. Parasini said.
Now, may I have you look at Exhibit UPNL 2 to Mr. Persini's testimony? It should be in the stapled packet that I got you. At the end of his testimony, there's
Exhibit 2, you said?
Exhibit 2.
I'm there.
This is a list of proxy company utility you use to compare with the company to determine the appropriate capital structure. Isn't that what the exhibit says?
That's what it says.
May I direct your attention to, keep that handy. I'm going to have you compare that.
Okay.
May I direct your attention to OCS Exhibit Number 3, which is a written testimony of Mr. Hathaway on page 2, line 9 to 15.
I'm there.
He states the purpose of this testimony is to provide the company's return on equity proposal. Isn't that correct?
What line in particular, I'm sorry?
Read line 9 to 15.
Where it starts with my testimony is divided into 5 sections? Am I on that
Yes,
page?
on one of those sections, this is capital structure.
And what in particular were you asking me to read?
I was just wanting you to confirm that part of his testimony is to run the ROE models for the company.
Mr. Hathaway was our ROE witness back in 1999, so I will agree to that.
Okay. Now may I have you look at Exhibit UPL 4 to Mr. Hathaway's testimony.
Okay. Okay, I think I'm there.
This is a list of proxy utilities he used to compare with the company to determine the appropriate rate of return of equity under the discount cash flow model. Isn't that true?
That's what it says, yes.
Now, comparing the list of companies to Mr. Brusini's exhibit concerning capital structure with lists of companies that Mr. Hathaway uses in exhibit used to comparable companies in his DCF modeling, both list the same companies. So both analysis must be using holding companies. Isn't that true?
For this rate case, it appears that that's what's happening, which again, as I noted, is not relevant to the list of companies that we're dealing with today. We're dealing with operating companies, and even actually Pacific Corp had different entities under it back in 1999. So I hate to say that, you know, we're in the same world as we were 27 years ago or 26, because we're not. So I can see that they're the same, but again, I'm not going to opine on why that was true when I wasn't the witness in that proceeding back then.
I'm more interested in the commission's behavior rather than the witness's behavior. The commission adopted the company's proposal using the holding companies for the capital structure analysis. That's true.
Back then, Pacific Corp had holdings in it that were not just the electric utility, so I don't want to opine why that decision was made. Because obviously I do not know. The commission may know.
I'm not asking you why, I'm just asking you whether that happened.
Well, if the question is if these two are the same list of companies, these two are the same list of companies.
Thank you. This is the last question. This means that the only Utah precedent that our Rocky Mountain Power cited for the use of a hypothetical capital structure provides that holding companies for the proxy should be used as a comparison for determining hypothetical capital structure, as argued by Dr. Woolridge, the OCS ROE and capital structure witness, and not the operating companies, as argued by you and Mrs. Buckley. Isn't that true? Miss Buckley, I apologize again. Isn't that true?
As I noted, back in 1999, we were in a different situation, and I referenced this example as precedent, as I noted in my rebuttal testimony, as precedent that the commission has established a hypothetical capital structure and that it could be used as a reference point.
I don't want to ask you the presidential effect of the commission's use of holding companies for capital structure, but I am going to say that the presidential value for the use of a hypothetical capital structure in the document, the only Utah PSC document also stands for the president, that you use holding companies, not operating companies. Isn't that true?
Again, I don't know that we've established whether they are or they aren't. Mr. Chair. Yes, I agree. She can answer whether she knows. I just don't think he's established. My original objection was that the documents don't say what he says they say, but I'm happy to let her answer what she knows.
Can you repeat the question, please?
I probably can do a little bit better.
Thank you.
You cited Docket 99-035-010 for the proposition that the Utah PSC has precedent in using hypothetical capital structures, and that they derive those capital structures from comparison to a proxy group of companies, correct?
Yes.
And the proxy companies they used in this docket were holding companies, correct?
Yes, and as I've said, I don't agree that that's true for a relevant comparison now, in terms of the operating companies or the companies that compare to Pacific Corp today versus 1999.
Thank you very much. That's all I have.
I am, thank you. Good afternoon.
Hello.
The division has some packets of potential cross exhibits it would like to circulate, and the division would like to do that now.
Please go ahead and do so.
Thank you. Commission first. The division will propose that the exhibits being circulated be collected as a packet by the recipients, please, as they are being distributed individually.
Sorry, say that again.
I'm not sure I understood that.
I didn't either.
I had said that the exhibits would be distributed as a packet, but they were not put into a packet due to my error, apparently, and so we are distributing them individually, and I will refer to the group as we go through.
Are all of them together considered DPU Cross Exhibit 2? Or
No.
They're different
They're
cross
different ones.
exhibits? Okay.
We did not prepare a book, and we are trying to do our best to expedite the proceedings, but I'm not doing a very good job, so I apologize.
There's no need to apologize, Ms. Schmidt. This is just fine. We'll just take a minute. Why don't we have we'll go off the record for 2 or 3 minutes. We won't call this our break, but how many are there altogether to distribute?
I believe 5.
Okay, we'll take a few minutes and allow us to distribute those. And if the parties and their counsel would like to confer in that period of time, we'll do so. But we'll go back on the record as soon as all 5 documents are distributed.
Thank you.
some exhibits disseminated while we took a brief break. Ms. Schmidt, will you describe what you've handed out?
I will describe each as I address it.
Do you
unless
want to
would-
move to admit them all together? Would you prefer to do it, maybe we ought to do it separately. Let's do it separately.
Thank you.
Okay, go ahead. But I'll just say that you've passed out, we already have received DPU Cross Exhibit 1, and you have now had distributed DPU Cross Exhibit 2 through 5, okay? Back to you for questions on the exhibits or other cross.
Thank you very much.
Before we jump in there, Mr. Chair, can I just, as it relates to OCS Exhibit 1, Cross Exhibit 1 that was not complete, I think we would want in the record the entirety of that exhibit, if we're going to use that. And I think you can just take judicial notice of it. It's a public order. So I'm not insisting on it now, but eventually that
No, I think that's a good point, and you can obviously pull that docket and give us the entire report in order, if you wouldn't mind. We'll substitute the entire 1999 general rate case order for the summary. That's okay. That's Mr. Moore.
Yes, that's fine. I do want to note for the record, though, that the commission's website has the order, but does not have a complete file. The testimony that Mrs. Kobia and I went over was retrieved from archives.
Okay.
But that testimony has been provided to all parties and is complete.
Yeah, that we already have that in the record. What we're being asked by Mr. Saban is just to give us the entire report in order as OCS Cross Exhibit 1 rather than the 5 or 6 page excerpt. And without objection.
Excuse me, Mr. Chair.
Yes.
If helpful to the commission and to the OCS, we have 7 copies of the complete 1999-035-10 order, if helpful.
That's helpful. And what we'll do is we'll receive OCS Cross Exhibit 1 as it is, and when you submit, are you going to use it in your cross?
If it's in the record for the OCS, then I don't.
You're not going to use it?
I'll refer to it, but I don't need it.
Well, let's admit it when you do your cross then. We don't need it now. It'll come in, we'll have both. We'll all be happy. Okay. Having resolved that, we'll go to Ms. Schmidt for cross-examination.
Thank you very much. Ms. Colby and commissioners and parties, what has been labeled as DPU Cross Exhibit 2 has been distributed. It contains excerpts from OCS witness, Dr. Woolridge's testimonies. These testimonies are not yet in the record, so we have prepared a cross exhibit. The testimonies from which these pages were taken was pre-filed in accordance with the scheduling order in this docket. With that, if we could turn to the second page of this stapled unit, which is entitled OCS-2SR Woolridge, and then across the top from that, docket number 24-035-04, Sir Rebuttal Testimony of J. Randall Woodridge, Ph.D. If we could move down to the bottom of that page, and we could take a look at what I will identify as Figure 1, Electric Utility Average Earned ROE and Market-to-Book Ratios, 2000 to 2023. Do you see that?
Okay, just a second, Ms. Schmidt. I'm sorry to interrupt you, but Mr. Woolridge's testimony will come in when he's examined, but I think we ought to have the cross exhibit admitted. So let's, are you moving its admission? Will you move its admission?
I will move its admission, and I could do that now if that would make things easier.
That would make me happy. thinks.
I'd
let's-
like to make it
I'd like to have it admitted before we ask a witness about it. And Mr. Saban or anybody else, is there an objection to this excerpt being admitted?
Yeah, I just want to, I don't object, I just want to note, it looks like it's a piece of the surrebuttal testimony of Dr. Woolridge as well as a page of the direct testimony. So just so
That's-
we've got a correct understanding of what it is.
I think the record should reflect that. I think it's one page of surrebuttal testimony, one page of direct testimony of Dr. Woolridge. Okay. No objections. The exhibit is admitted.
Thank you for the assistance.
You're welcome.
Turning now to the bottom of the page containing the surrebuttal testimony of Dr. Woolridge and the table. If we look at the table, we can see at the top a legend that has the ROE in blue and the market-to-book ratios in gray. Do you see that?
Yes.
Would you agree with me that generally the average earned ROE has decreased over the last few years? This exhibit may not provide this specificity to see that, so if it is difficult to see, please let me know.
Yeah, there's no trend line listed here, so it's difficult for me to opine on a trend. And I guess I'll also say I'm not the witness on the ROE.
You are the financial person, so that's why I'm asking you this. But I'm
Okay.
happy to ask it of Ms. Bulkley.
But I guess if your question is what the ROEs are doing, a trend line would be useful to be able to opine on that.
Moving on, I believe that the market-to-book ratios shows what I would call a trend line. Do you agree?
In reference to the gray triangled box?
Yes, please.
It definitely shows some data. I don't know if, I can think of a trend line if you've ever seen a chart that has hey, I've taken all these data points and I've drawn a line. I don't know if I agree this is a trend line per se. It's data points.
In that case, I will rephrase my question. Would you agree that the data points show a decrease from 2020 to 2023 on this chart?
Well, as I look at 2020 looks lower on the chart than maybe 21 and 22, but then I can see a drop from 22 to 23. Again, that's sort of kind of visually trying to imply without knowing the full scale of the numbers.
Thank you very much for the clarification. If we can turn now to the second page of this exhibit, which is page 21 from Dr. Woolridge's direct OCS Exhibit 2D. Can we look at the top figure on that page, please?
I'm there.
Figure 7. I'd like to note that the blue line represents the data for electric utilities, and the red line represents the data for gas distribution companies.
Yes, I see that.
Can you see, or do you agree that, actually, I'm going to withdraw the question, and I will move on. If you'll give me just one moment. And then I will ask Ms. Bulkley questions about this exhibit later as well. Thank you. Okay, moving on to what has been pre-marked for identification and is distributed as DPU Cross Exhibit 3. This cross exhibit contains excerpts from SEC filings that were circulated to the parties last week, period. I can provide for the record, copies of the SEC filings in entirety if requested, but I suggest that the pages contained in DPU Cross Exhibit 3 represent true and correct copies of those pages, and that, if I may be so bold as to say that the SEC filings are hundreds of pages long, and I would hope that the excerpts will be all right and may be admitted. So with that, I request admission of DPU Cross Exhibit 3.
All right, does anybody have an objection or comment that they want to make about the statement about the entire 10K and 10Q filing?
Yeah, kind of a similar comment. I realize that they're voluminous. Without knowing what it's going to be used for, I think we'd probably generally prefer to have the entirety of the exhibit in so that we can see the context. I'm happy to let her use this as recognizing that it's a subset of those pages. That's fine.
So, Mr. Saban, I think we're all cognizant of the fact that those filings are very voluminous. I don't think we need them in the record. If something comes up in the context of the examination where you're concerned that the excerpts here misstate something, you can come back and we'll visit this again. But I think I'm inclined, and I will rule that we're not going to put in the entire 10K and 10Q filing at present, and that we will receive DPU Cross Exhibit 3, these excerpts from the filings as exhibits in the record.
Thank you, and I will reiterate that the complete SEC filings were provided electronically to the parties last week.
Yeah, that, and Mr. Chair, you may not understand, you may not know this. When we were given this exhibit, we were given the entirety of the exhibit, not the excerpts. And so I assumed we were going to be submitting the entirety into the record, because I don't know what she's going to use this for, and there may be counter information some other place. I just don't know.
Let's have you reserve your objection if you're okay with that.
That's fine.
And if you want to reassert it at the end of her examination, you'll do so. But my ruling at present is we'll just put this in the record, and then we'll revisit it if we need to with respect to the entire filing. Okay, you can go ahead, Ms. Schmidt.
Thank you. Ms. Kobia, could you please take a look at the second, third, fourth, pardon me just one moment. At the Form 10K that is attached for the fiscal year ending December 31st, 2020, the first page is what I will call the cover sheet. It identifies the filing companies and the date of filing and the date of the applicable filing. The second page is an index. The third page, page 99 in the packet, addresses legal proceedings. Page 100 addresses some other issues. Page 203 in the packet addresses some other issues. And page 254 addresses some other issues. So I would like to focus on page number, sorry, 3 of the 10K packet, and I would like to direct your attention to item 3, legal proceedings that are addressed and contained on this page. Do you see those?
Yes, yes.
Will you agree that this 10K filed for the year 2020 references wildfire litigation as specified in the filing itself for 2020 as a legal proceeding for Pacific Corp / Berkshire Hathaway Energy Company.
There is a section of the 10K, as you can see, that addresses legal proceedings. I think perhaps the important thing to note is there's also a footnote to the financial statements that talks about the accounting associated with it that I don't see anywhere in these excerpts, and so that would be very relevant if we're going to talk about the legal proceedings.
In that case, I would like request permission to get the footnote references and provide them.
No objection.
Thank you. Now if we turn to the 10Q that is attached and stapled to what's been pre-marked as DPU Cross Exhibit 3, I'll identify this 10Q as the quarterly report for Berkshire Hathaway Energy Company that was filed for the period ended December 30th, 2024. Do you see that?
This was for the quarter September 30th, 2024? I thought you said December, I'm sorry.
I probably said December.
Yeah, I haven't done December yet. It's coming, but I'm just not quite there.
I'm just wishing, and I have my quarters mixed up. Anyway, thank you for the clarification.
No problem.
So if we turn to the second page of the 10, apparently there is an index on the back of the title page, and then the next sheet is the Berkshire Hathaway Energy and Pacific Corp legal proceedings. Do you see that?
Yes, and I would say same comment, there will also be a footnote in this 10Q.
And I'd like to note that the description of the proceedings goes from page 212 through 221. Do you see that?
Yes.
I would also like to request permission to add the footnote information to the 10Q and submit that as an exhibit.
I'm never going to remember this. That's, permission is granted, Ms. Schmidt. Absent any objection, I don't think there'll be any, based upon the previous lack of objection. We'll be taking a break in about 10 minutes because we're going to end at 3:45 for the public witness. I don't know if that's something you think that you could have someone in your staff provide from these public documents that are on file, and you want to come back and ask questions with respect to that when you have the footnotes?
I'm just asking the witness and the commission to take notice of the content therein. I am not sure that we could obtain copies in the 10 minutes.
Okay, well, you can provide those when you will.
Thank you very much.
Okay, continue.
Turning now to what has been pre-marked as DPU Cross Exhibit 4 and identified as Rocky Mountain Power's response to OCS Data Request 4.6. I will note that Rocky Mountain Power's complete response to this data request was provided to the parties earlier, and this, like with the SEC filings, is a carefully curated subsection of that Rocky Mountain Power response. And I would like to move for its admission at this point, if you would believe that would be proper.
Sure, absolutely. Any objection?
Just one question maybe. Are you saying this is the entirety of 4.6 or is some subset of that?
I believe that it is the entirety of 4.6, but I will need to double check that, and I appreciate you bringing that to my attention.
If it's all of it, I'm fine with it.
Okay, subject to check. We'll assume this is all of 4.6, and we'll receive it. If it turns out that there's more to 4.6, we'll have you bring that to our attention, and then we'll address it at that point in time. Okay, you can proceed.
Thank you. Ms. Kobia, will you agree that data request 4.6 seeks information concerning the dates and amounts of cash dividend payments made to Berkshire Hathaway Company by Pacific Corp, DBA Rocky Mountain Power Company, and 2 cash equity infusions made by Berkshire Hathaway Energy Company into Pacific Corp, DBA Rocky Mountain Power Company. And at this point, I will correct myself and say that the data request 4.6 attached is only the cash dividend payments, not the cash equity infusions. So with that, I'd like to proceed.
So you're saying that there's other portions of this
It appears
of this data request that needs,
that I am not going to address.
Mr. Sabian, do you need those submitted, or are we okay to proceed with just?
Why don't we
have
try and see if we can do it with just what we've got?
That would be appreciated. Thank you. All right, let's go forward.
Thank you. Turning to the next page in this packet, do you see a list of dividends paid for 2010 through 2023 May? And I will represent that this is a copy of what was provided as an answer to the first part of the company's response to OCS data request 4.6.
I see dividends from 2011 through 2023, if that was the, not 2010, and I know these numbers, I'm familiar with these.
Thank you very much.
And this data request, and if you actually look at the question itself, it asked about 2022 to 2024, and there were no equity infusions in 22 to 24, so that would not be relevant.
Thank you. I will just note that I should have read more carefully because the heading of the document is 2010 through May 2023, and I didn't notice that it began with 2011, or with 2011. Okay, moving on. So, to what has been pre-marked as DPU Exhibit 5. This is an exhibit that the DPU prepared this morning, and I'll represent that it contains a spreadsheet listing the 10-K filing, the description of legal proceedings, and not the footnotes, a description of dividends paid, and then the response to OCS data request 4.6 showing dividends paid, and the years covered by this exhibit are 2020 through 2024. I would like to request its admission, and I can provide more context if desired.
All right, let's see if anybody has an objection with what you've already stated, if they need more context. Any objection to this DPU Cross Exhibit 5 being admitted?
Just to expedite things, I'm not going to object to it. I just want to know for the record, this was a DPU-created document, not created by Rocky Mountain Power, and I have no way of sitting here and verifying whether the data on this DPU document is correct or not, because I don't have the underlying information before us. But
the underlying information was provided to you earlier again, and the underlying information was provided in what has been admitted as SEC excerpts.
I understand. What I mean is, I've never seen this document until today, that exhibit DPU cross exhibit number 5. So I didn't have the ability to go and verify whether the information in these columns or the chart is the same as in the documents that were provided. That's all I'm saying.
Thank you, Mr. Saban. We'll receive this. I also will note that some of this information with respect to dividends paid is found in the pre-filed testimony. So it's subject to check, and if you find that there's any discrepancy here that you disagree with, you can bring it to our attention later. But having said that, you can use this document however you choose, Ms. Schmidt.
Thank you. What I would like to do is refer to DPU Cross Exhibit 5, and I will have just a few questions on that. So subject to check, do you agree that DPU Exhibit 5 shows that SEC filings from 2020 through 2024 addressed legal proceedings related to wildfire liability?
Yes, I agree. There was wildfire liabilities disclosed in our financials, and I noted the footnotes are very important to this conversation.
They will be forthcoming. Thank you. Then I'll move on to the last column, which is RMP's response to OCS data 4.6 showing the dividends paid. And do you see that?
Yes, I see those numbers.
So do you agree that in 2021, there was $150 million dividend paid to Berkshire Hathaway? In 2022, a $100,000 dividend, and in 2023, a $300 million dividend paid to Berkshire Hathaway, and the total of all those dividends paid was $550 million. Do you agree with that?
Well, I'll restate since I believe you missed some zeros. Yes, there was a $150 million dividend paid in 21, $100 million in 22, and $300 million in 23, which totals the $550 million.
Thank you. Thank you for your correction. I need new glasses. So do you agree that after the Labor Day fires in 2020, when the company knew it had potential liability for wildfire claims, the company paid over $500 million in dividends?
This definitely comes back to the footnote conversation. So as we see in the legal proceedings, there's the disclosure around the particular trial, the one case, as we know what we were aware of back then. But if you look at the footnotes and what we actually knew as probable wildfire liabilities, it's evolved over time. So to say that a dividend was paid and we knew about wildfire liabilities, that is absolutely true. But the extent of the wildfire liabilities, I think, is completely relevant, which gets disclosed in the footnotes.
Okay, Ms. Schmidt, could we take our break now, and then you could have time after we're back from the break? If you want to look for the footnotes, you can, or you can do that later. But let's, unless you're within 2 minutes of wrapping up, I think you probably have more examination.
I have more, but again, before we break, I would like to say that I believe I said potential liability in my question.
And that's what I said was potential liabilities.
Thank you. Just a point of clarification I needed to make.
Okay, are you okay with the break now then?
I'm okay with the break, and I
Okay.
will need to ask more questions when we return.
Sure.
And provide the footnote information later.
Okay, we will be back at 2:45, and we will continue until 3:45, when we'll break for the public witness hearing. Yes, yes, I'm sorry.
No, thank you, Mr. Chair. I don't know if this needs to be on or off the record, but during the break, we also have a fair number of documents that we've circulated to the parties ahead of time, but would, in the interest of efficiency, want to distribute them during our break. And so.
No, that would be great. Let's do that during the break, and you can feel free to approach the bench here and put them on the commissioners' spots, their seats, and we'll go from there. Okay, we'll be back at 2:45. reconvene here. And before we go to Ms. Schmidt for continued cross-examination, I suspect there may be people already here who are going to participate in the public witness hearing starting at 4 o'clock. Are there folks here for that purpose, if you raise your hands? Okay. We have some folks from the Office of Consumer Services, OCS, who are going to circulate a list. You want to get on that list if you want to say something. And if you're the only one here, I won't make any more of the announcement. We'll make that later. Okay. All right. Go ahead, Ms. Schmidt.
Thank you. So I'll come back a little bit to some of my earlier questions that do involve the footnotes, and I'm hoping that your general knowledge will allow me to ask these questions. If not, I can re-ask them after the division has submitted the SEC filings with the footnote material, which will be tomorrow, I believe. Anyway, so do you agree that in 2020, the company knew that it faced potential liability with regard to the wildfires in 2020, but it did not know the exact amount of that liability at that point?
So as I noted in my rebuttal, the company follows generally accepted accounting principles. And to the extent that we know something that is probable, we're recording that on the financials. So at that time, we knew there was an event, and we did, made estimates every year, and we continue to make estimates and update them every year associated with those liabilities. So there's sort of an evolution to it.
And the James verdict was in the spring of this year, is that correct?
In June of 2023.
In June of 2023, last year. Okay, I'm obviously in my own world. Sorry about that. Okay, so if we look at the potential liability, and if we look at the fact that Rocky Mountain Power paid dividends, can we say that the company's capital position, financial risk, and access to capital markets would have been significantly improved if it had retained the $550 million in dividends as an accrual against potentially significant wildfire claims?
Can you repeat that?
Yes.
Sorry.
Is it fair to assume that the company's capital position, financial risk, and access to capital markets would be significantly improved if it had retained the $550 million in dividends as an accrual against potentially significant wildfire claims?
I don't know, since that is not the situation that we find us in. So that $550 million of cash would have been used for potentially something. I can't say necessarily what. And so it's hard for me to conclude what the world would look like that I'm not in.
Okay. If the company guesses wrong about its wildfire risks and hasn't taken steps to protect its financial position, is it your testimony that ratepayers are or should be responsible for higher rates to repair the company's mistake?
So I guess maybe I need to hear that again.
That's a long question, so let's ask the court reporter. Could you read that back?
I guess I don't believe that we're asking ratepayers to pay for the company's mistakes. When I think of the wildfire liabilities specifically, there's no seeking recovery of those items in this case. There, of course, are knock-on effects to what happens with our capital structure and those pieces, and so we're seeking a balanced outcome and regulatory support so that we can move forward and keep the credit rating that we have and the strength of the utility. We want to maintain that so that we can continue to provide reliable, safe power to our customers.
Just one moment. If higher rates are awarded associated with the wildfire liabilities, and I'm not going to get into whether or not they'd be discussed here or in phase 3, but how would the commission hold the company accountable for mistakes that could prove influencing?
I'm just going to object to that. I think, again, that lacks foundation. I think the witness just clarified that we're not asking for that. And the follow-on question was the same premise.
Thank you, Melissa. Would you like to rephrase the question in any way?
If you'll give me just one moment.
Certainly.
I'll withdraw the question.
Okay.
Is it fair to say that the company's current capital position is suboptimal?
The current in what particular time period are you referring to?
If we turn to your direct testimony at lines 61 through 68, you say that the company's capital position heightens financial risk, although that may not be an exact quote of your words.
So are there specific lines you're
Lines
pointing me to?
61 through 68?
And that question was around how our proposed capital structure differs from our forecast capital structure? Is that the question you're?
I believe so.
You could have it read back if you'd like, Ms. Schmidt.
I'll accept that that was my question and
Okay.
look forward to the answer.
I guess perhaps I could read something if that's what we're seeking, where I've stated in here, as a result of incremental wildfire liability accruals through 2023 and settlements that have been reached thus far in December 2023, coupled with our capital expenditure plan, that our actual capital structure has become and will continue in the foreseeable future to be more highly leveraged, which is riskier. Is that what you're seeking? So yes, I've stated that in testimony, that we are at a riskier position from our capital structure because of multiple events, the wildfire liabilities being one of them, and then our significant capital plan that we have that we're seeking to, not only mitigate wildfire liabilities, but just for the operation of our system.
And in this case, the company is proposing a hypothetical capital structure. Is that correct?
Yes.
Under the company's proposed hypothetical capital structure, would the company receive additional revenue than if the actual capital structure was used?
If looking at the math, if you have a 50% capital structure versus this forecast of 44, and all else remaining equal, even though I don't agree with that premise, that the company would receive a higher amount, but that's where I think it gets complicated, is that all these factors are dependent on one another. So if you change a capital structure or a different equity level, then you should reconsider what the ROE looks like, and if that's going to trigger actually a more leveraged company, there's risk of a downgrade, which increased debt costs. So it kind of all plays together. So mathematically, 50 versus 44, absolutely. But I just don't think that's a great premise because so many of these factors play with one another.
And so you referenced 44%. Is that number in the division's capital structure proposal for its common stock?
No, the 44% I'm referring to on my table 3, I actually report that the forecast 2024 and 2025 capital structure is looking to be 43.93 or 44.42, and I shortcutted that to 44 as a midpoint or an average. So that's where my 44 came from.
I have a different question regarding a different 44.
Okay, yeah.
So, Mr. Coleman's direct testimony has been pre-filed. It has a Table 2 on page 5. This table does not contain any confidential information, and I'd just like to read what his capital structure and cost of capital point estimates are from the DPU.
Sorry, could you give us those page number? Is it direct testimony you said?
It is his direct testimony. It is Table 2 on page 5. If it is easier, I do have copies of his direct testimony with that table. In his direct testimony, he also references the company's proposed capital structure, and I have that available as well.
I have it. Do you have a copy of Mr. Coleman's direct?
I have Table 2 from page 5 in front of me, if that was your reference.
Yes.
Yes, I have that in front of me.
I think we're good. I've got it and she's got it.
So, all things being equal, which may not, would you say that under the company's proposed hypothetical capital structure versus the division's proposed capital structure, and the company's structure has a weighted average cost of capital of 7.45%, and the division's has a weighted rate of 7.0%, Utah ratepayers would pay more under the company's hypothetical capital structure?
Yeah, I think I just addressed this, that I don't agree with the premise of all else being equal. Obviously, we can all do the math and see that 7.4 is higher than 7. But as I noted, if we're moving to a space of a higher leveraged company, that creates different risk. And so the ROE, for example, that the company, I think, could support would be a higher number, which that would change. And I'll say Table 2 of Coleman's testimony, I would say that would result in a different return on equity. Also, if that's going to create additional risk and cause credit downgrades and increased debt cost also has to move. So I think there's so many different scenarios that you could look at for how to get to a 7.45 or a 7 that it's difficult to judge which one. I would say all of them could end up being the least cost. And math, obviously you can see the math, but I think there's just too many interdependencies here to agree with that premise of all else being equal.
Thank you. I'll leave it with at the math. Thank you very much. Those are all my questions. And I would like to I'd like to make sure that I've moved for the admission of DPU exhibits 2, 3, 4, and 5. Yes.
Thank you, Melissa, once again. By about day 5, I'll get this all figured out, okay?
I'm hoping to have it figured out by day 5, too.
Yeah, I usually speak without a microphone. I'm pretty loud. I think we've received 2, 3, and 4 for sure. Did we receive Exhibit 5? Melissa, do you know? I thought we received all of them, but just to be safe, I know we received Exhibit 2, 3, and 4. We want to move for admission of Exhibit 5, receive that into evidence.
Can you give me just a moment to look at what Exhibit 5 is?
It's this document right here. It's the summary of the SEC filings. I thought we moved, and it was received into evidence. Remember, the discussion was whether we were going to file
Footnotes?
footnotes was,
That was SEC filings.
yeah, but I think we did receive this into evidence. I'm quite sure. But if you want to do it again, move to do it again. It's not going to matter.
I'd like to move to do it again just because that's the way my day has gone.
Okay, it's been moved to receive DPU Cross Exhibit 5 into the record. It's evidentiary record. Mr. Saban?
Nothing other than what I previously commented on, so.
Okay, all right, thank you. Anybody else? All right, it will be received. It is received. Thank you.
With that, the division has nothing more at this time for this witness. Thank you.
Okay, we have 45 minutes before we have to adjourn. My estimation of the additional cross, I wonder if we would, Mr. Russell, would you like to go next? I think yours is shorter than others.
It is. In fact, I'm not going to ask any questions, so
Oh, okay.
we'll keep it short.
Well, we can be done for the day then, Russ. All I was planning was you. All right, so let's go, we'll go to Sophie Hayes. Ms. Hayes.
Good afternoon, Mr.
Would you
Chair.
like to go for next?
Well, I don't have a preference for order. I have about 10 minutes of questions.
We know how that goes, so your 10 minutes may stretch longer, but let's have you go next, if that would be okay.
That is okay.
Yes.
Ms. Kobia, I forgive you if you don't look at me at all.
It's kind of rude, but.
You don't need to swivel. Can I take you to your direct testimony at page 5, lines 86 and 87?
Yeah, I'm there.
Okay. You say, first, the credit rating of a utility has a direct impact on the price that a utility pays and the ability to attract the capital necessary to fund its current and future operating needs. Did I read that correctly?
Yes.
Great. The price that a utility pays for capital and the ability to attract capital are two separate concepts. Is that right?
Yes, but they often play together.
They play together.
Yeah.
Right. That's fair. If you go down to line 90, you say a further credit downgrading has the potential for the company's senior secured debt ratings to drop below an A rating, thus further limiting the company's access to capital. Did I read that correctly?
Yes.
Great. Will you turn with me to Mr. Lynn's direct testimony at page 31?
Don't think I printed him his testimony. If I could get it from somebody.
I have, ooh, that's super small print. I have it on my computer.
I think, yeah, someone here might have it. Just a second.
Please, yes, you can do that.
All right, what page again, please? Oh, well.
Page 31.
This has his resume. Let me find, must be somewhere else in the book. Not in this one.
Should be right. Sorry, I just saw it. Lynn, right there.
All right, page again, I'm sorry.
31.
31. Okay, yes.
I'm going to ask you to look at the graph that's between lines 513 and 514.
Yes, okay.
Are you familiar with this figure provided in Mr. Lynn's direct testimony? That is S&P's table showing global corporate debt amounts by rating category.
I'm familiar with it in his testimony, but not beyond that.
Okay. Are you aware that S&P publishes the size of credit markets at various credit ratings?
Yes.
All right. This table, according to the note below it, shows the amount of bonds, notes, loans, and revolving credit facilities rated by S&P. Is that correct?
Yes.
Do you have any reason to believe the data presented by S&P showing the amount of bond placements across all debt ratings is incorrect in any way?
No.
All right. If you look at the graph in the fourth column from the left, the column labeled total, and it's showing total debt amounts in billions of dollars. Is it fair to say that Pacific Corp, at its current BBB rating, is in the most liquid portion of the market?
Yes, I can agree with that.
Okay. And the amounts decline for each category in either direction, but are still quite big numbers. Is that correct?
There are a lot of numbers here, yes. Some higher, some lower.
Yeah. If you look at the difference between the A category and the BBB category, there is actually a larger market for the BBB category. Is that right?
Yes.
Okay, so it's not correct to say that dropping below an A rating necessarily limits access to capital. Is that right?
I think the challenge becomes this is very much a big picture view of the world. Sorry. And that the devil often becomes part of the detail. And so I think, we look at our investor population, and as I noted in my testimony, even at our downgrade, we had investors drop off. So that's great that there's this money available, but it doesn't necessarily lend you to conclude that, Pacific Corp will be the one getting that money at whatever applicable rating we're talking about.
Are you aware of any reason that makes Pacific Corp less competitive for access to investor funds than other corporations of the same rating?
I think the challenge right now is the overhang of the wildfire liabilities. So I can't say that relative to other companies what's going to happen. I just know what we see with our investors in our bond offering and their reaction to what's happening to us in our situation.
All right. Are you familiar with the utility PG&E in Northern California?
Yes.
They've had significant wildfire costs and have gone bankrupt twice. Is that right?
Yes.
They nevertheless have been able to raise billions of dollars of debt despite that. Is that right?
They have, and I would conclude that they're potentially a price taker, and I'm seeking not to have Pacific Corp be a price taker where we are desperate and only get debt at a extremely high cost because we're junk status.
All right. Well, that's a good segue. Not the junk status, sorry. That was misleading, sorry. If you will go with me to your direct testimony at lines 271 to 273, let me tell you.
Am I done with this book by any chance? Am I done with
think
Lynn's testimony?
You're done with that.
Okay, good.
Yeah.
I'll just close it up so I have some space.
Yeah, so these lines are on page 14 of your direct testimony.
So, said my direct, line 14?
Sorry, page 14.
Oh, thank you.
Lines starting at 271.
I'm there.
Okay. You say the issuance of long-term debt requires a credit rating, and maintaining the company's credit rating is critical in providing constant and affordable access to the debt capital markets. Did I read that correctly?
Yes.
What do you mean by maintaining in this statement?
In this statement, I'm referring to the current ratings that I disclosed on one of the other tables. I can't remember the table number, which had our senior secured debt at A2 and A.
Okay. So basically staying where you are, not going above or below.
Sure, yeah.
Okay.
Yep.
Can you tell me what affordable means in this statement?
Yeah, affordable is, definitely us seeking to be the best rating that's possible, looking at our credit metrics so that we can get a favorable cost of borrowing. When we're, A-rated or even the triple B plus rating, there creates a great tension between the company and the investors out there so that we actually get the best price point possible for that rating. And that's what we're seeking to do, is to have that favorable tension across us so that we can get the best rating and cost for the debt we issue that will then, of course, get passed on to customers.
Great. Do you acknowledge that customers are not exactly in the same position as shareholders when you're referring to affordable debt?
So shareholders in what context?
Shareholders who are seeking affordable access to capital.
So maybe you need a little bit
Sure.
more clarity on.
Sure. I guess I'm trying to draw a distinction between what Pacific Corp and its shareholders view as affordable versus what customers view as affordable. And so I think, all else equal, customers could potentially save money from a higher cost of debt if a downgrade in credit was triggered by something else that lowered their bills, like a reduced ROE.
So that I think we're back to this all else equal sort of concept again, that as we look at our credit rating and the need to issue debt, and as we've said, we have a significant need for borrowings for our capital expenditure program, we're seeking to have the lowest cost of debt to the extent that we're further downgraded or we're more highly leveraged than shareholders would seek a higher return. So we might be back to there's a point where those two all converge again, and I think I maintain the position that we are seeking to have the least cost rates possible for our customers, and their view of what we're doing, I hope they have the view that we are actually looking out for their best interest to try to have all of those dynamics at the lowest cost possible.
I think it is appropriate, however, it is on, but I'm not speaking into it. I think it's appropriate, however, for someone who is asking questions on cross to ask you to hold variables constant and then give your best answer that you can. All things being equal, we understand your position is all things are not equal. But if a question's phrased to hold this variable and this variable constant, what's the impact that you see on that? If you can answer that question, please do so.
Would you like me to rephrase
Let's hear it again.
Question? Thank you. A reduced return on equity would reduce the weighted average cost of capital overall, even with higher interest rate on debt, all else equal. Is that right?
It's going to depend on how much the debt cost moves.
Yeah.
So I can't say without, I'm sure there would be examples where that is the case, but without a specific example, it's hard to conclude on that.
All right. I have no further questions.
Okay, let's, Ms. King, I think my estimation is that from what you provide, you have over about an hour of cross. Let's turn to, what's that? Let's turn to others, and let's see, Captain George, do you have any questions of this this witness?
No, I don't, Mr. Chairman.
Okay, Ms. Kobia? Okay, well,
If helpful, Mr. Chair,
yes,
perhaps we can try to move through the exhibits and deal with those as something of a procedural matter.
yes, let's do that. You won't finish your cross date. Unfortunately, you'll have to be on the stand again tomorrow. But let's go, we'll go another 27, 28 minutes, and let's get through as much as you can, and let's go ahead and handle the procedural matters first, and then we'll see how much you can get into your cross.
Okay, so just a point of clarification, Mr. Chair, would you like me to present and, if appropriate, move the admission of the cross-examination exhibits before getting into the body of my cross?
I think so. We could do those all together, and we could take any objections as they come up. But let's do that.
Okay, thank you. So for the record, just to get started, good afternoon, Ms. Kobia. I'm Michelle King. I'm here on behalf of the Utah Large Customer Group. It's nice to see you again. I'd like to talk with you about capital structure, and for purposes of the large stack of paper you have in front of you, let's caption this, a history of capital structure at the Commission. The first document, do you recognize as the report and order from the 99035-10 rate case, which you cite to in your testimony, in which you had a discussion with OCS counsel, Mr. Moore?
Yes.
And do you recognize this as a complete copy of that decision?
I would not know how many pages it would have been otherwise. Is there a signature at the back that has me conclude it's complete? I have no reason to dispute that.
Okay. I will submit to you that this was a complete printout of the decision off the Commission's website.
Great.
And so if you have no reason to dispute that, I would like to move the admission of, this will be UTLCG Cross Exhibit number 3.
Okay. Is there any objection to the admission of that exhibit? Okay, it will be received. Thank you.
Thank you. The next document in your stack, so in your testimony, if I could briefly refer you to page 10, where you reference the decision number 99 from the 99 case. And at the footnote 7 there, we see that the date that that was issued in cross-examination Exhibit 3 is May 24th, 2000. Do you see that?
Yes. Mm-hmm.
Okay. So the next document in the stack, I will describe to you as a true and complete copy of a printout of the report and order issued just 6 months before, on November 23rd, 1999, in docket number 98-2035-04, which is the report and order governing the Scottish Power Pacificor merger. Do you recognize this document?
Sure. I know that there was a merger that occurred, so I have no reason to argue what it is.
And are you aware of the timing of when that merger occurred relative to the decision that you cited in your testimony?
That sounds correct. Yeah, 1999 was about the merger time.
Okay, then I would move the admission of UTLCG Cross Exhibit number 4, please.
And this is the entire report and order, as you indicated. Okay. Is there any objection to that report and order being received? Okay, it is received.
Now, going back in time to something that's more recent, in the most recent rate case before this one, that was in 2020, was it not?
Yes.
And you provided testimony in that proceeding?
Yes, I did.
And does this look like the testimony you provided in that proceeding?
Yes.
Then I would move the admission of UTLCG cross-examination Exhibit 14 rate case in docket number 13-035-184.
That sounds reasonable.
And do you have reason to doubt whether this is
Mr. Williams' testimony in that proceeding?
I have no reason to doubt that.
Okay, then I would move the admission of UTLCG cross-examination exhibit number 6.
6. Without objection, okay, it'll be admitted.
Thank you. Continuing in our time machine, the next two documents that you have are from the rate case that preceded the 2014 rate case. This was the 2011 rate case in docket number 11-035-200. The two documents are an application that's before you, followed by, again, as the footnote reveals, the testimony of Bruce Williams. I will note for both the commission, the witness, and the parties, we circulated copies of these exhibits last week, with the exception of the application appended. And what we realized when we printed out our copies of the testimony is that there was no indicia of what docket that testimony was filed in. And so I'm happy to walk through the linkage between the application and the testimony. The application is simply provided for purposes of identifying the docket number that it was filed in.
And are you going to have that marked as UTLC cross 7?
Yes.
And then the testimony is cross 8?
I would intend to have them linked together.
As one document?
Yes.
Okay, lay your foundation on the linkage, please.
Okay. So first, Ms. Kobia, do you recognize that before you, you have an application for general rate increase in docket number 11-035-200?
Yeah, I have no reason to dispute that.
Okay, and so I'll refer your attention to page 4 of that application, please. And there's no line numbers. See, we've done it better over time.
For sure.
But I'll refer your attention to the paragraph 8, the third sentence, where it says the revenue increase for which approval is requested is based in part on an ROE of 10.2%, as recommended by Samuel C. Hadaway. Do you see that?
Yes.
Okay, so now the appended document, which is the testimony of Bruce N. Williams. I'll refer your attention, please, to page 2. And the first full question there, where it references what is the overall cost of capital you're proposing. And in the second line of the answer, he references that this cost includes the return on equity recommendation of 10.2% from Dr. Samuel C. Hadaway. Do you see that?
Yes.
And so do you have reason to question whether this testimony goes with and supports the application that we've been discussing in this proceeding?
I have no reason to dispute that.
Okay, so I would move together as a cross-examination exhibit, UTLCG cross-examination exhibit 7, please, these two documents together.
Okay, without objection, we'll admit both of these together as UTLC cross 7.
Thank you. And so we're going to go through that exercise 2 more times with everybody else's indulgence and patience. I know it's late in the day. The next 2 documents in your packet, the first document is an application for general rate increase filed by Rocky Mountain Power in docket number 10-035-124. Do you see that?
Yes.
And then the second document appended to that is, again, the direct testimony of Bruce N. Williams. Do you see that?
Yes.
Okay, so I'll present to you the linkage data between them. If we can please turn to page 4 of the application.
Yes, I'm there.
And in paragraph 7, roughly halfway down the paragraph, is described Dr. Hadaway's testimony that an ROE of 10.5% accurately reflects market circumstances. Do you see that?
Yes.
Okay, so now let's look to the testimony of Bruce Williams. And I'll refer your attention, please, to page 2 of Mr. Williams's testimony.
Yes, I'm there.
And at line 33, he references the ROE of 10.5% from Dr. Hadaway. Do you see that?
Yes, I do.
And do you have reason to question whether this testimony goes with this application from Rocky Mountain Power in this docket?
No reason to question that.
Okay. Then the UTLCG would move UTLCG cross-examination exhibit number 8, please.
Okay, without objection, we'll receive these two together, the application and the testimony that's been, the foundation's been laid. It's UTLC Cross 8.
Thank you. One more time, for the people in the back. The next document I've placed before you is an application for general rate increase in docket number 0903523. Do you see that?
Yes.
And it's an application for a rate increase from Rocky Mountain Power, yes?
Yes.
And then accompanying that in the second document is again the direct testimony of Bruce N. Williams. Do you see that?
Yes.
And I'll present the linkage data to you now at page 4 of the application. In paragraph 9, do you see that it references the placement of generation-related projects in service between the historical base period and the test period ending June 30th, 2010?
Yes.
Okay, so now I'll refer your attention to Mr. Williams's testimony on page 2. And at line 33, in response to the question, what time period do your analyses cover? Mr. Williams references the test period in this proceeding is the 12 months ending June 30, 2010. Do you see that?
Yes.
And so, given that data, do you have reason to doubt that Mr. Williams's testimony supports the application in docket number 0903523?
I have no reason to doubt that.
With that, then, UTLCG would move the admission of cross-examination exhibit number 9, please.
Okay, without objection, those documents will be received together as UTLC Cross 9.
Thank you. And finally, in the packets before you, we've circulated a copy of the legislation from the 2024 session that has been referenced in various discussions that you've had on the stand. I believe you've had today. If not, Ms. Stewart has certainly. And so I'm happy to either move this now or to approach this when the time comes in the course of my cross-examination.
You can move it forward now.
Okay. Ms. Kobia, do you recognize this as the legislation enacted by the Utah legislature in the 2024 session, which you can refer to the description that's provided, but which establishes the creation of a Utah Fire Fund?
I have no reason to dispute that, but I'm not directly familiar with this per se.
Okay. I would nonetheless move to admit UTLCG cross-examination exhibit number 11. There's number 10, I'm sorry. There's been significant conversation about wildfire risk and the need for regulatory support. And in my cross-examination with Ms. Kobia tomorrow, I'd like to talk about this in the context of that conversation.
I just have one question about it, is whether this is the enrolled bill. It doesn't indicate. This is SB 224. Looks like it's the second substitute. But do we know if this is the, there would be an enrolled bill that would state that. But
Mr. Chair, based on my understanding, yes, it is, but I'm not positive, and so I want to make sure that I'm honest in my statements to you. We can confirm that over the evening, and I can follow up with you tomorrow on that.
Okay. What we'll do is without objection, we'll admit this. If you find out that this is not the final version and you have a enrolled bill, you can substitute it tomorrow.
Thank you so much. So with that, would you like me to start, or shall we make room for the public commenters and reconvene tomorrow?
Well, I'd like to get, I don't want you to be in a position where you feel disadvantaged. It's you start and you can't really get into your cross-examination, but I guess I want to see if there's any objection. We have 9 days of hearings scheduled, and we're not making a lot of progress yet. So we do have some risk associated with it if we end 15 minutes earlier than we'd planned. But we do have a pretty significant preparation for the public witness hearing that's going to begin at 4 o'clock. Does anybody have an objection at your peril. No, I was teasing. Does anybody have an objection if we end 15 minutes earlier than planned?
We're fine.
Okay, all right. Well, you're the ones I was most concerned about,
Yeah.
if you're a witness, and, all right. That's what we'll do. We're going to stand adjourned until those of you will be present for the public witness that hearing. That'll be in at 4 o'clock. Otherwise, we will reconvene at 9 a.m. tomorrow morning. Thank you.